says, he said he did not know. That's the answer to the question. And I think that's where the court ended up. That's the only.
No, where the court ended up, and we talked about that yesterday, was the he said he did not know was to the version that the state had proposed that said this was planned beforehand. And the answer was he doesn't know that.
Right, but what we discussed at the bench earlier, and the reason we asked for this portion, but that sentence, the sentences reads, he thinks shooting Peanut was not planned, but more impromptu, or at least very short or little planning, is because that is speculation. That's his opinion. The fact, and you agreed earlier that.
Yes, with regard to whether it was planned or not, that's a separate issue from whether he knows personally that it was done by a member of YSL.
But maybe I'm just not understanding, because I took the court's previous ruling and I thought that they were going to redact. As a matter of fact, they agreed that they were going to redact that particular sentence. That's the only thing that we objected to, because that our position was simply opinion. It was speculation. The fact that it came from Mr. Wright doesn't make it any less speculation as to him trying to explain why his client thinks that. But we asked that be kept out. The court agreed, and we thought that that part was not going to be read to the jury or presented to the jury.
I don't think that part has changed.
It was the email, but that's what we discussed, because we were discussing whether or not these correspondences, including the emails, were going to be presented as evidence. The state said, well, we don't know, we might, we may, and our position was that, well, if this gets presented, we don't want that line should be redacted, just like the other line where they proposed the line about
what he had said.
Right.
Yeah, right. And that's what we're talking about right now. But that's an entirely separate thing from what number 8 ultimately ended up saying. So if Ms. Love is going to somehow get from whatever it was he said, hang on.
Number 4, Ms. Rice's email.
If she thinks she can get from it was pre-planned, no, he didn't know that, he couldn't say that, to somehow that answer being the basis for putting in he personally knew somebody did it. I mean, I don't know how she's going to get from one to the other, but obviously that is what they ultimately decided was okay to sign, and y'all can cross-examine Mr. Wright on that.
Your Honor, I'd also point out that how we got where with any of these assertions is not relevant or pertinent to whether or not the defendant, it does not make more or less likely whether the defendants did or did not do anything here. So how we got to any of these, in my opinion, is not relevant.
Well, Ms. Love, you're the one that's putting them all into issue right now.
I'm putting them into issue to impeach what Mr. Slayer said regarding his regarding whether his.
Okay, so I think that you can ask a few more questions that establish that, yeah, there were very material alterations made from what it started to what it ended up with. And they were made at the request of Mr. Sledge. But frankly, you even have Mr. Wright on the stand saying, but there were other things that the state wouldn't change. So how you deal with that is up to you. But
since I want him to put in front of the jury everything that he recalls as being true, I don't care about the truth getting in front of the jury. I am talking about this idea that the state.
Well, the easiest way to do that is, so what was it that you wanted changed that didn't get changed?
Right.
And then why is it that well, that would be speculative, but I just said I wasn't going to tell y'all how to try your case, but okay. So we are not at this point going to be admitting any of these.
We're not
just going to be discussing them with him.
At this point, correct.
All right, yes, sir, Mr. Steele.
Your Honor, just to follow up on, I believe Mr. Shart said, would you also go through an analysis of confrontation clause, because the statement now comes from a party opponent and it's used for litigation. It is a clear, to me, bullseye on confrontation clause. So it's really Ms. Love who should be testifying if the state wants to get that in, because that is a confrontation clause, because where it came from, all those questions cannot be cross-examined to Mr. Wright.
Well,
Second, okay.
Okay, sorry, I thought you were
No,
finished.
second part, and I apologize, I'll be very brief. Second part is a 403 analysis. It's like saying, Ms. Love saying to Mr. Adams, who represents me, did Brian Steele destroy the murder weapon in your presence or in the presence of Mr. Harvey? And then Mr. Adams responds, no. That's really bad for a jury. That is really bad. And that's really what's going on here. So I would ask you to just limit it. The point is what you said. Did the state give ample opportunity?
Wix gives you the power of AI to build the website you need.
Answer, yes or no.
Mm-hmm.
Did the state make those changes? Yes or no? And he might say some not. And we may have to go into a portion by portion, but otherwise, I think that it's a wrong witness because of the confrontation clause, and I think it's very prejudicial under 403.
Okay.
Your Honor, we've had the witness on the stand that made the statements, that signed them. We've inquired of him. He's
Yeah, I
made
think that
some.
does take care of the confrontation clause issue. And with regard to 403, I mean, I agree. We've spent the whole morning on this, and let's target the questions to get to the cogent issue, which is, were they able to make material alterations upon request? All right.
Yes, Judge.
Okay. So we ready to get the witness back in and the jury back in? Yes.
It is cold in here.
I'm sorry.
I mean,
Mainly.
I have a heater that he can use if he's cold,
oh no, I mean,
so we don't turn it down.
I'll soldier through it.
I can get my heater.
I was just wondering, is it me?
No, it's cold to
I'm
almost
good.
everybody except for the judge and the deputies.
And Ms.
And a couple of the jurors who are fanning themselves because you're too hot. And, but yes, it's not an ideal temperature for everybody.
No, I'm good. Thank you though. Yeah. Observer President Company.
Mr. Wright, I'm going to put in front of you states 1A as once more.
Okay.
And I'm also going to put in front of you states 452, Yankee. Are you able to discern, are you able to tell whether, and I'm putting in front of you states 460, Yankee, which has been admitted as evidence.
Okay.
And are you able to determine if 460 Yankee was sent in response to 452?
I don't know that that's been admitted. 450 was
452
admitted.
hasn't, I haven't,
No, I don't, did you say 460 was submitted?
I believe, yes, 460.
And it hasn't.
It hasn't?
Only 450.
Okay. Your Honor, the state. Because of, okay. Without reading anything from 460, thank you, Judge. Without reading anything from 460, are you able to tell if 460, the last two pages, were sent in response to 452 Yankee?
I do not believe so.
Is there one or anything that you have a record of that occurred between when 452 Yankee was sent to you and 460 Yankee was sent from you?
Okay.
Without saying what it is, because we haven't entered anything as
Okay.
evidence. Do you have a record of any correspondence that occurred in the middle?
The record would be in reviewing my emails and without going into the contents, there's what I saw and had on the 27th of December, and then what we were interfacing back and forth on the 28th when we were in court.
Do you, looking at 452 Yankee, is 452 Yankee, did you say earlier that that accurately reflects an email sent to you on December 27th?
I did. But I'm looking and thinking there were at least 4 versions, but there might have actually been a little bit more. But when I'm looking at what I thought was the first version, which is what I thought my response was to, it looks like this may have been an updated first version, meaning I'm just seeing some slight differences. That's why I'm hesitant to just say, yes, that this is it. I can't say, is this iteration that was in that process of getting us to the end? Yes.
All right. Are you able to say if there is any material change from the number 1 under the factual acknowledgement section from 452 to whatever version you're looking at that you think you might have been responding to?
To jump
Just number 1 under factual acknowledgements, number 1.
okay. Number ones are,
Don't
one
say
is,
what it is.
one is the same.
Okay, my only question relates to number 1.
Okay.
All right, and so as it relates to number 1 on the factual acknowledgements that you were responding to when you sent 460Y,
Mm-hmm.
is that number 1 the same as in 452Y?
Yes.
Is that the same in the document that has been admitted as 1AS in a prior hearing?
Just to. Yes.
And is that the same as number 1 on State's Exhibit 444Y?
All right, we already established that 1AS and 444Y are the same document, so we don't need to ask that question for all of them.
All right, Did you convey in 460 Yankee that I have in my hand that you did
Okay.
have? Did you convey in an email to the state on December 27, 2022 at 8:43 p.m. that is a part of 460 Yankee? Did you convey changes that needed to be made to the plea agreement in the form that you were looking at, whichever one it is?
Yes,
Were those changes reflected in the document that is 1AS? And I don't need you to read any
yeah,
of
yeah,
them.
no, I was gonna say, all except, all the changes were ultimately incorporated. The only issue with the document 1AS is number 8.
Okay, so are there any changes that you saw need to request that you do not see reflected in 1AS? And they don't have to just be in states 460. Are there any changes in 1AS Are there any changes that you asked to be made that aren't made in 1AS? Material changes.
What I'll do is. go-
Number by number on,
Well, first with number 3, we indicated,
wait, you cannot say
Okay.
what's in there.
Okay.
I just need you to roll it.
number 3.
I don't know of any ruling that the court has made that says he can't indicate what the change that he requested being made. And that's what I understand that he was about to explain.
Your Honor, it's going to get into,
So the question was, are there any changes that were requested to 1AS that were not made? So he's entitled to answer that question.
okay?
And if you want a full answer, we don't know what he's gonna say, so
Yes,
is the final
So
document
that
that got
question-
signed.
right.
So, given all of our discussions, Ms. Love was trying to be careful about so if you're objecting to okay.
So, Mr. Wright, would you just follow along with me and let's do this exercise using only the numbers
Mhm.
under the factual acknowledgement section in document 1AS? May we do that?
Yes,
All right.
So can I make a suggestion? 1AS is, or a version of it, 444Y is in evidence. Would it be beneficial to display it?
Man, hit the like button, hit the subscribe button for me. Hit the like button, hit the subscribe button for me. The shit is free, man. Hitting the like button and supporting my streams is free. We got a lot to break down this morning, man. Hit that like button, hit that subscribe button. I appreciate everybody that's coming into my stream. Like I said before, you don't have to watch my stream. You don't have to watch me. You feel me? If I pause and I talk, you don't have to watch me. You can go to another stream and watch. So make sure you hit the like button, hit the subscribe button. And if you want to donate to the channel, make sure you hit that Cash App. You feel me? Make sure y'all hit that like button. Make sure y'all subscribe to the channel for me.
Your Honor, my understanding is it's not in evidence.
444Y is, and 1AS is the same document.
So,
I don't
Is it not?
believe it is. And I,
Can we take a look?
Please do.
and Your Honor, if we can approach, I can explain. We already discussed this at the bench.
Okay, no, you're right. I remember. Okay, never mind.
Just saying numbers,
Correct. If we could just use the numbers,
I would say.
and I'm going to address them one, is that okay?
Sure.
All right. So, was there a material change as it relates to number 1 of 1AS that you requested that was not reflected in number 1 of 1AS?
No,
Is there a material change to number 2 of 1AS under factual acknowledgements that you requested that was not made?
no,
Is there a material change to number 3 of states 1AS under factual acknowledgements that you requested but was not made?
3, yes.
So we'll put that down. And we'll come back to it. Was there a material change to number 4 in states 1AS that you requested that was not made?
Hit the like button, hit the subscribe button, man. Hit the like button, hit the subscribe button.
Was there a material change to number 5 in states 1AS under factual acknowledgements that you requested that was not made?
No.
That Mr. Sledge requested that was not made?
Yet I still believe, Your Honor, that we are entitled to get those emails if there's any
Which is why,
exculpatory material.
Miss,
Was there a material change to number 6 of States Exhibit 1AS under factual acknowledgements that Mr. Sledge requested through you that was not made?
No,
Was there a material change to number 7 under factual acknowledgements as reflected in States 1AS that Mr. Sledge requested that were not reflected in number 7 on 1AS?
no,
can you just say same question for number 7, same question for number 8?
Okay. Same question for number 8. And if I think number 8
Yes.
wasn't on a prior,
and yes, but, and again, it wasn't on a prior edition, but it.
was on the
added to
last
this one.
edition.
So, but
So
the
I can't.
subject matter was one of the things we said.
Okay. So, Your Honor, I can't ask the same question. Okay. All right. Number 9, was there a material change regarding number 9 that was requested by Mr. Sledge through you that is not reflected in number 9 under factual acknowledgements of states 1AS?
No,
Is there a material change to number 10 on states 1AS under factual acknowledgements requested by Mr. Sledge that was not made on the final document?
no,
Same question for number 11.
no,
Same question for number 12.
no,
Same question for number 13.
no,
Same question for number 14.
no,
Number 15, same question.
no,
Number 16, same question.
no.
As to the sentencing acknowledgements that are reflected in states 1AS under section 5, did you review those? Are you comfortable telling the jury whether or not you went over those sentencing acknowledgements with your client? Just yes or no before you explain anything.
I would have went over the entire agreement, including that section, yes.
Okay. Did you allow your client an opportunity to ask any questions that he needed to ask?
Yes,
Did you restrict his ability to ask you questions?
no,
Based on your knowledge of over 15 years of interacting with your client, did your client appear comfortable asking you anything he wanted to ask you?
yes,
Did you answer your client's questions as thoroughly as you could possibly do in your capacity as his attorney?
Yes,
Did you answer them in a way that based on your 15-year knowledge of him, you believed he fully understood?
I hesitate. My answer would be yes, but again, I'm not a mind reader. So other than perceiving his responses to me and that he seemed comfortable, I can't purport to say what all is going through his mind.
I didn't ask you that.
Yeah.
I appreciate your response. I appreciate your clarification. So I asked the question I did for a reason. Based on your 15 years of knowing him,
Mhm.
did he give you any indication that he did not understand any one or more of the provisions under number 5 sentencing acknowledgements, which are in 1AS?
No,
And when you said yesterday that you had represented Mr. Sledge in 2 cases over the last 15 years that were felonies and one that was a misdemeanor, would you explain like what it is, how you're able to determine when he doesn't understand something as it relates to a plea and how you're able to determine when he does understand something? What does he do when he doesn't understand something?
well,
Your Honor, I'm going. Same objection.
Sustained.
How do you decide that something needs more clarification when you're interacting with Mr. Sledge?
with Mr. Sledge or any other client,
I just
go-
need Mr. Sledge.
Well, the point is, I'm going to state what's, I guess, in front of us in terms of what any particular paper is going to say. Make sure that it appears to me that he understands it. Give him an opportunity to ask any questions if he doesn't understand it. And then in a document such as this, where he's going to initial, that's just another way of him indicating that he has seen it. He's had an opportunity to discuss it with me, and he doesn't have any questions that we need to address to the court or follow up.
And do you pay attention to body language when you're asking him if he understands something?
Yes,
Do you pay attention to pauses or hesitations when he responds in order to determine if he just doesn't want to say it or if he really understands it?
I don't speculate and go that far.
Uh-huh, yes.
I'm trying to get a direct response so that I know how to proceed. But I understand your question, but I'm saying I generally am not going to try to surmise based on just body language. If there's something that creates a red flag for me, then I'm going to follow up with a question.
Your Honor, I'm going to ask a question that's going to harken back to something yesterday. It's going to sound not relevant. I ask the court's indulgence for a moment for me to ask this question. You remember yesterday when you were telling the jury that a particular question sounded like a hot topic, and I asked you, what did you see from me that made you think it was a hot topic?
Understood.
Okay, so when you're talking to your client, what do you look for to see or make you feel like he does understand something?
I'm listening.
Object. I believe that question has actually been asked and answered.
Sustained.
Are there nonverbal cues that you look for to see whether or not your client understands something?
I would say yes. I mean, I'm looking at their facial expression. Do they seem to be very clear on what we're discussing, what the topic is, what their response is? And, obviously if the client is very emotional, that's the more obvious. But I'm just trying to make sure, have you heard it? Do you understand it? And what is your answer? And then ultimately, we go from there.
Have there been instances during this plea or any other with Mr. Sledge where he's asked you the meaning of certain words that he did not understand?
I don't have a specific recollection of him asking about the definition of a word. However, anytime he had a question about the content of a statement or what that means, he did not hesitate to ask me.
Okay. Did you take care to explain what you would consider legalese or legal terms to Mr. Sledge that you thought he may have a problem understanding?
Anything that is of a legal effect, legal character, I'm going to make sure he understands in very plain terms, him or any client, what that means.
Did you go over each one of the 6 sentencing acknowledgements, both before and at the time that Mr. Sledge signed or initialed the 6 sentencing acknowledgements in states 1AS?
Yes,
And what about the last paragraph underneath that 6th sentencing acknowledgement? Did you go over that with him before and at the time that Mr. Sledge signed the document that is labeled 1AS?
yes.
Is there anything you haven't talked about that you now can think of that makes you feel in any way there was something he didn't understand?
Objection calls for speculation.
Sustained.
All right, let's go past that. Thank you, Judge. When you signed states 1AS, was it at the same time that Mr. Sledge put his signature above yours?
It would have been immediately after, yes.
All right. And on the same date that it was signed by the DA, by the assistant district attorney that is indicated?
Usually he'll sign it, I'll sign it, then I'll present it to you and then get your signature.
Okay. Was there any material addition that you asked to be included in State's Exhibit 1AS that the state refused to include?
There was no addition, no.
Okay.
Or rather, let me say it this way, no addition that we asked
Okay.
that was not included.
Okay. Was there something you requested be taken out of the plea agreement that is a part of states 1AS? And I stopped that question right there for a reason. Is there something you requested be taken out?
Yes.
And is it contained within a number?
Number 8,
Okay. And at what point did you request that number 8 be taken out?
even in the very beginning in my initial email, we were given an indication that he did not have information.
Wait a minute, you're getting into it. I'm asking you about a time frame, just the
Okay.
time frame because of,
From the very beginning.
Okay.
That was one of the things that was an issue for us.
was number 8 included in any previous iteration
I would have,
before states for based on your notes,
Mhm.
what iteration did the date and time that number 8 first appeared in,
well,
based on your notes? And without saying what number 8 is.
understand. And let me work my way backwards. I'm going to look through the earlier iterations, but I can tell you the one before this exhibit, which for my records was iteration number 3. It was not in there. So the subject matter of number 8 had been removed from earlier versions, was not present in iteration number 3, such that it appeared again in iteration 4.
And so would you tell me, or the jury rather, what iteration between states 450 and states 456. And including states 452. What iteration of that agreement did number 8 first appear in? Just by date
Okay.
and time and exhibit number. If it's in there.
Okay. It was not in 451Y.
Do you understand the question I'm asking?
Well, no, I am. I'm sorry. I'm answering in a way where
So with-
iteration by iteration, I'll be able to say if it appears at all. I do not believe it appeared in any prior iteration in that form, but I'm looking to just make sure the
Time doesn't heal all wounds. Hard work, innovation, and we can. Corewell Health.
You are the future. Pursue tech careers with the DeVry Scholars Program. Advance your ambition.
just reach yourself.
okay. Okay. In 452Y, number 4, the subject matter of that appears. It does not appear in 454Y.
Just if you see it.
It appears in 456Y, also number 8.
Okay.
And I had skipped over 455Y, but it does not appear in 455Y.
So as you read over and initialed 1AS with your client. I'll take these.
Yes.
Did you come out, did you ever speak to the state about number 8? To the best of your recollection, did you request that number 8 be removed?
No, I did not. I have no recollection of seeing number 8. I understand my client initialed it because I can see his initial. I also understand it may have been enunciated by the state at the plea, but where we went from 455Y, where it was not in there, and then it was in there, I don't know how it got there or how we missed it, because neither my client or I appeared to have realized it was there and it came in.
Are you saying that you did not read this document before you all signed it?
No, we read it and signed it. I can't dispute that. But
And-
how that number, when that was something from the very beginning we were contesting, I can only say we missed it and it's in there.
All right. And when you say you were contesting it, how were you, how did you contest it? Without saying what you said, but how did you contest it?
Well, by telling the state that that information, that's the subject matter of that, is not something that he has knowledge of or information on. So I'm sort of hamstrung to answer your question.
All right, we'll come back. And so at the time that this document was being read into the record, were you paying attention?
I was paying attention, but I missed it. So apparently not good enough. Just as when I went over it with my client, which I did, I'm not saying I didn't, but that is something that to this, I mean, it sort of was a surprise of this trial for me, was that was in there. And how did we miss it?
And when you speak of that was a subject matter, beyond it being something you referenced in, you said it was, you saw it in referenced in 452 Yankee number 4, and you saw it in 456 Yankee as number 8, the final iteration. Is that fair? Did I get
Correct.
that right? Okay. Do you have notes, or do you have an email or a text message or anything that reflects, hey, 456 or number 8 on this document, not the final, but number 8, take it out?
To answer your question.
No, hit that like button, man. Double tap the
What was
screen.
happening,
Hit that like button, man. Support the show. I'm about to pause this. Man, support the stream, man. 160 in this bitch and only 9 likes. Hit the like button, man. Double tap the screen. That's all y'all gotta do. Just double tap the screen. It's not that hard. Just double tap the screen. Make sure y'all hit the like button, hit the subscribe button, man. Double tap the screen, hit the like button. So all y'all got to do is double tap the screen, man. Hit the like button. 160 in the chat. Hit the like button. Double tap the screen. Yeah, Jamie, this is live.
It's not in there, and everything seemed consistent with what we had asked. When we were handed 456, I think we must have assumed, and I don't want to speak for Mr. Sledge, well, that 455 was what was being handed to us to execute. And we did not notice because, again, it's an addition. It's a completely different sort of addition, and it's in there. And again, I'm not disputing it is in there, but I can't explain to you how we missed what we thought we were signing, or what I thought we were signing was 455, not 456, with that additional number 8 embedded in the factual allegations. And I don't have an acceptable explanation.
Yo, I'm a keep the stream running, but when they gon' break, y'all, I'm gonna be back. When they gon' break, I'm gonna be back. I gotta go take care of some business real fast, but I'm a leave the stream going until I get back. I'm a leave the stream going until I get back. Give me like 30 minutes. I'll be right back. Make sure y'all hit the like button. Make sure y'all hit the subscribe button for me.
As to how we missed it.
Okay, so looking at 455, and Your Honor, this is one of the last 3 questions I have. Looking at 455, is 455 Yankee number 8 what you're referring to when you said that you thought 455 Yankee was the last iteration?
Correct. And I'm not going to go into it, but the subject matter of number 8 in this is different than what number 8
All right.
in 456s.
And so is 455 Yankee number 8 what you were trying to agree to?
Yes.
Okay. All right. And does 455 Yankee have 13? How many factual acknowledgements are in 455 Yankee?
15.
And are there 16 in Stacy Exhibit 1AS? There you go.
Yes, there's 16 in 1AS.
And beyond was there anything in particular about number 8 on 1AS that you brought to the state's attention at any time before now?
In the very beginning, without going into the subject matter,
You can give me just date and time if there's an email you're referring to.
on December 27th, the email at 8:43, item 4
Okay.
was related to the subject matter of item 8.
Did you respond specifically to item number 4? I mean, did you respond specifically to item number 8 when you wrote item number 4?
Hold on one second. I'm looking for the iteration I had when we sent those responses. It may be. If you could hand me, I guess, the first version or first updated version, then, because I think I've got my stuff intertwined now.
Okay.
But what I was going to say, because I was going to reference what the subject matter of number 4 is.
You can't do that.
Well, not out loud, but what I was going to say is, yes, it's the same subject matter.
And were you speaking specifically to a number 4 in a previous iteration when you wrote and responded to number 4?
Correct.
All right. Your Honor, thank you. I think that's all that I have for the witness right now.
All right, cross-examination.
Your Honor, for the record, I'm just putting 1AS back with Ms.
All right,
Winfrey, and I'm taking back the ones that were not admitted.
thank you.
You're welcome. This is my.
I think that's it.
Good morning, Attorney Wright.
Good morning.
I believe we met briefly to introduce myself yesterday or the day before, but again, I'm Doug Weinstein and I am Diamante Kendrick's attorney.
Yes, sir.
If I speak to you in a normal speaking voice, can you hear me okay?
Absolutely.
I don't need to yell or shout.
You do not.
Okay. We talked about proffer sessions, and a proffer session, again, I believe you said, is when a defendant meets with the state, correct?
Correct.
So to avoid legalese, I'm just going to talk about meeting with the state instead of using that word proffer. Okay?
Yes, sir.
All right. So if there would have been a meeting between Mr. 𝐔𝐧𝐢𝐭𝐞𝐝 and the state, you would have been there, correct?
Yes.
Was there a meeting between Mr. 𝐔𝐧𝐢𝐭𝐞𝐝 and Attorney Love before December 27th?
No, not that I have any recollection of. And I was, I never want to give an incorrect answer, so I was cautious, but I don't believe we ever actually sat down for a proffer.
Was there a meeting between a meeting between Mr. Sledge and Attorney Hilton before December 27th?
No,
Was there a meeting between Mr. Sledge and any member of the any attorney in the district attorney's office before the 27th of December?
not that I'm aware of, no.
What about an investigator with the attorney's office?
No.
I have a slight objection just as to clarification because I'd ask that the meeting part based on other interactions, just vague. Was there any
Okay, the
meeting?
objection is vague.
Okay, let me clarify. When I have used the word meeting, what I mean is a proffer session. So to all of those questions, if I had used the word proffer session, were there proffer sessions?
I'm not aware of any proffer session that was ever conducted or even a more informal interview with anyone from the DA's office or law enforcement as it relates to this case.
So there being no proffer sessions, I believe you received the first proposed plea agreement on December the 27th with a series of factual acknowledgements, correct?
Yes.
So how in the world, to your knowledge, did the state come up with those factual acknowledgements for your client to agree to without having met with your client?
Your Honor, I'm going to object based on relevance and speculation as it pertains to how the state did something or came up with something.
Overruled.
I believe the state was trying to surmise through its overall
Well,
investigation.
now, he asked your personal knowledge, so if you could answer that, please.
I don't have any personal knowledge how the state came up with these factual problems.
So you don't know how the state put those words in your client's mouth?
I do.
As to the characterization of
Sustained.
Okay. How many plea negotiations have you conducted in your career?
Definitely over 1,000, maybe 1 to 2 or 1 to 3,000 over 30 years.
Okay. And these plea negotiations are like any other negotiation that takes place between parties, correct?
Absolutely.
There are things that you want in the final agreement, right?
Yes.
They're the things the state wants in the final agreement, correct?
Yes.
Do you get everything you want in that final agreement?
No.
And is this plea any different than the other pleas where you don't get everything you want?
No, it's not.
I have no further questions.
All right. Does anybody else have questions from the defense?
And Your
for
Honor, I
this
have
witness?
a motion as to part of that, but I'll ask it at the time that we break.
Okay. Mr. Adams.
Attorney Wright, good morning, sir.
Good morning, sir.
Like Mr. Weinstein, you and I have known each other a long time, haven't we?
Yes, sir.
All right. Got a number of questions for you, and I want to break them down into separate parts, okay?
Okay.
And same ground rules. If you can't hear me, you don't understand the question, just ask me to repeat myself, clarify, whatever you need, and I'll be happy to do that.
Understood.
All right. Let me kind of start where Mr. Weinstein left off. Proffer session has been referenced, which is a meeting between your side, you and your client, and the district attorney's office. Never happened. True?
Correct.
Sustained.
All right. You did receive, as we've seen previously, that email with the proffer agreement attached. Is that right?
Objection, asked and answered.
I did.
Sustained.
You have never seen, never received, and there is no signed proffer agreement.
Objection, asked and
Anyway,
answered.
is there?
Sustained.
And your interest in representing Mr. Sledge would have been to try and in whatever the best situation was for him. Isn't that true?
Objection, vague and relevance.
Overruled.
Absolutely. In anything, the best interest of my client, that is tantamount. That is the absolute goal. Is, I want not just keep them home, not just some things you might think. I want the best possible solution for the case.
In this case, in representing Mr. Sledge, you indicated you'd known him for well over 15 years, true?
Yes,
And at the time that you came into this case, you were aware of the indictment and exactly what he was charged with in the indictment.
yes,
You knew that he was charged with one count of RICO, or violating the racketeering in the RICO Act.
yes,
You knew that he was charged in count 30 of the indictment with possession of a firearm by a convicted felon.
I did.
The count 30, the possession of a firearm by a convicted felon, is something that he was accused of. The allegation was that he committed that offense in December of 2021. Is that right?
Yes,
Right, and that was included in the overall indictment with the RICO count. True?
yes,
Okay. Having represented Mr. Sledge before, you knew not just him, but you knew his family as well.
yes,
You knew his mother.
yes,
And so when you were in court over the course of the last number of days, and you heard testimony and questions about him wanting to get home to his sick mother, is it in fact true that his mother was ill?
yes. I have personal knowledge that at the time we were going over this stuff, that was something he expressed and was stressed over.
That was a concern of his.
Yes,
You knew, and I want to kind of reference some dates. He was arrested somewhere in June, around June of 2022. Is that right?
that's, I'm relying to some extent, but I'll say to the best of my knowledge, yes.
Well, you know that the case was indicted. The indictment was handed
Yes.
down in May of 2022.
Actually, that being the case, yes, he was arrested not long after.
Okay. You, and I don't want to delve too deeply into it, but you shared that at least in the early part of that, you were having some health concerns yourself.
Yes, and let me back up a little. The reason I paused on my answer was, remember, there was sort of an earlier part where he at some point had charges related to this. Those charges ultimately went away. Then much later on, there was an indictment and then an arrest. That's why I sort of paused, because that earlier date is not immediately known to me. But as to once this case was indicted, then the arrest, even though I was not back to my practice yet, I was aware of it and was sort of watching from the sidelines.
Okay. You were in court and heard when he was testifying about that previous matter you're referencing. In other words, his
Yeah.
arrest and where he was charged with the murder of Donovan Thomas.
Correct.
And so at the time that you come into this in 2022, you have knowledge that detectives with the Atlanta Police Department had previously charged him with Donovan Thomas's murder and then ended up dismissing him or dismissing the charges, right?
Objection, relevance.
Goes to his
Overruled.
Yes, that's the point. I was aware from before. So when this occurred, it wasn't necessarily something new to me. I was already aware that there was some history.
You mentioned a couple of dates when you were testifying earlier. We talked about you getting into the case somewhere around October or November of 2022. Is that about right? And when I say get into the case, when you were healthy enough, right,
Correct.
to kind of resume your practice and get into Mr. Sledge's case.
Yes, sir.
Okay. By the time you would have interacted with him or started representing him on this case in either October or November of 2022,
Mhm.
he would have been in jail for a number of months, true?
Correct.
He would have been in jail at the Fulton County Jail, true?
Correct.
And since he was in jail at the Fulton County Jail, that presupposes, and you know, that he did not have a bond.
Correct.
Now, if you're in jail and you don't have a bond, you stay in jail. True?
Correct.
The only way you get out of jail, if you're in jail without a bond, is your case gets dismissed, right?
Correct.
Or you negotiate some sort of plea or deal that gets you out of jail, right?
Correct.
Or you go to trial and you get acquitted, and that gets you out of jail.
Correct.
Mr. Sledge wanted to get out of jail.
Yes.
He had been in jail for a number of months by the time you spoke to him, and he was anxious about getting out of jail, wasn't he?
Objection, Your Honor, asked, answered, and
Sustained.
He discussed with you his desire to get out of jail. True?
objection, asked, answered, and it gets into,
Attorney-client privilege.
yes,
Sustained.
Were you attempting to get him out of jail?
Yes.
All right. Now, Mr. Sledge, you were in court previously when there was some discussion about what an offered plea is that right?
Yes.
All right. Now, and one of the ways that a defendant, Mr. Sledge, could resolve a criminal case is with what's called an offered plea, right?
Yes.
Now, an offered plea, as you would have discussed with Mr. Sledge in one of his previous cases, revolves around someone saying, I'm not guilty of the charge, but I'm going to plead guilty because it's in my best interest. Is that right?
Correct.
Right. And you would agree with me that entering a plea of guilty, whether it's under offered or just a straight guilty plea, can sometimes be in a person's best interest, right?
Oh, absolutely.
And that may sometimes be regardless of whether they consider themselves to be guilty of the offense or not.
objection,
True?
Your Honor, relevance.
Correct.
Oh,
Correct.
Because as you've testified previously, people enter pleas for different reasons. Isn't that right?
Correct.
You having, were you the one who did Mr. Sledge's bond hearing, or was it another attorney?
It was probably me. I just don't have it was a while ago. So.
Okay. It was in late 2022. True?
Well, you know what? No, his arrest on this, I wouldn't have been able to do the bond hearing. So I'm not sure who represented him for the bond hearing as it relates to that June arrest.
Okay.
I was thinking of the old case, but as to that, I would have to say, no, I was still on the sidelines where I wasn't cleared to practice yet.
Right. One thing that you became aware of, though, when you came onto the case in late 2022 is that, as you indicated before, Mr. Sledge did not have the resources to go to trial.
Correct.
And it is true, as he testified. Did you hear his testimony about that?
I did.
And did you testify also earlier that you knew that he had limited resources and he just didn't have the resources to take this case to a year-plus trial, right?
It was something that was heavy on my mind in terms of when I'd be able to return to practice, to be able to assist Mr. Sledge, because knowing he had limited resources. And even, I guess, because of the relationship over the years, even though he didn't have the resources I would have liked to become involved in this case, I was going to do what I needed to do to help him. And therefore, even though it wasn't, a huge fee for, or resources for a big year plus whatever kind of trial, I wanted to get involved, make sure I'm here to get him out of this situation and help him in this case. So I know that was a long answer to your question, but yes, it was something actually heavy on my mind, which made me say, let me get back, be healthy, and effective in making sure I can represent them.
One of the things that you would have discussed with your client, with Mrs. Sledge, would have been the risks of going to trial. Is that right?
Yes,
That is certainly something that you would have counseled him to consider in regards to what decision he made. True?
yeah, every client, we're going to have that conversation.
It is true that you would have counseled him that, hey, look, Mrs. Sledge,
Objection, Your Honor, when it gets into specifics of the risks that Mr. Wright considered existed in this case, I think that that is privileged information unless now Mr. Sledge has waived.
All right, well, Mr. Wright understands the obligations of the attorney-client privilege, so please
And-
do not reveal any attorney-client privileged information.
And I was going to say, I cannot answer that question because you're asking me something specific to Mr. Sledge.
sure. What you knew, though, is that had he gone to trial and been convicted, he would have been facing a potentially long period of time in prison.
I would say I would know for any of my clients that when you're facing these kind of charges, the potential consequence of a conviction could be a very lengthy sentence. So it's extremely serious. So you want to make sure you can stand guard and do the best to make sure you get the best result for your client.
And that is something that you would, without going into any specifics, that is something that is a factor that you would have discussed with Mr. Sledge. True?
Again, not specific to Mr. Sledge, but to all my clients, to make sure that their eyes wide open. We talk about the good, the bad, all the possibilities, so that you can make sure as an attorney that my clients have a full understanding of the risk, the reward, and all the possibilities in between, so that they make an informed decision on what they want to do.
You were aware, were you not, that the state, the district attorney's office was interested in whether or not your client would testify, would take a plea and testify? You knew that, didn't you?
Yes, as of, I think the first email was sometime in November, when sort of the first communication that sort of gave us an idea that they would like to talk to him.
Were you ever present in court where any representations were made by an assistant DA that we're looking to make deals?
I first appeared in court in middle of December. That's sort of when I came back, but I also appeared on behalf of Mr. Sledge. I don't remember the details of what occurred that day, but I will say, when I reached out to the state to say, hey, let's talk, it was middle of December. So it was after, I think, that first couple court appearances in December.
Okay. It would have been after, also, there was that November 30th correspondence between you and the state. True?
Correct. I had not yet responded to them, but it was in middle December that I essentially was now responding to them and saying, okay, well, let's talk.
And that November 30th email was an email that you received from the state.
Mhm.
It was unsolicited, true?
It's easy when you have emails to say, I remember this. It may have been a phone call where it is customary that even though you may see us in court, everyone seems to be one side or the other arguing. Professionals, we call each other, we talk, we communicate about different cases we may have going on. So it was not unusual for Ms. Love or someone from her office to just reach out, call me, as sort of that first step. And I think there might have been a phone call followed by that email. But again, I just don't have a recollection of a phone call or what the conversation is, but it wouldn't have been unusual. I've known Ms. Love probably 10, 12, also maybe 15 years.
Okay.
So it, as one professional to another, it would not be unusual for her to reach out to me to basically see, is my client interested in something?
Now, during that period of time, from November 30th to whenever it was you reached out to the DA's office or started having some conversations with them, you would have been talking to your client about what he wanted to do in regards to resolving the case, true?
Clearly, with all
Can
my,
you move back towards the mic, if you don't mind?
yeah, with all my clients, I'm going to communicate to them, hey, here are communications or statements or developments, anything about their case. So again, not talking specific with Mr. Sledge conversations, it is my norm and usual that if the state reached out to me, I would have made sure to reach out to him. And more often than not, I don't like jail phones. So I don't want to be listened to. So I will try to go see my clients and have that conversation.
At the jail?
At the jail.
I want to backtrack a little bit and ask you, you testified just a moment ago that you weren't sure as to whether or not you represented Mr. Sledge at the bond hearing in regards to this case. Is that true?
Yeah, I just don't have a memory. I may have, but I may not have. I just don't want to misstate something.
Would it help to refresh your recollection about whether or not you represented him at the bond hearing if I were to show you a document?
Absolutely.
Can I first finish, Your Honor?
Okay.
Yeah.
Yes, please.
I'm going to show you for purposes of the record what I've marked as defendants Williams Exhibit 257A and 257B respectively. I'm going to go ahead and put those to you, let you take a look at them, Mr. Wright, and once you're done, you just tell me whether or not that helps to refresh your recollection as to whether, as to who represented Mr. Sledge at the bond hearing in this case.
Yeah.
Okay.
Seeing this, it does refresh my recollection.
Okay. So tell me if you would, whether or not you did in fact represent Mr. Sledge at the bond hearing in this case.
I definitely filed for bond, and I either represented him myself or I had someone stand in for me if there was an actual hearing, because I'm not sure in that time frame that I had filed for it whether I had been cleared. So I can at least state I filed for it and I either was there and represented him or I had an attorney stand in my place.
When the bond was denied.
So it's still on me. Yes.
Okay. All right. So let's jump back to December now, right?
Okay.
So we're in December, and if I heard you correctly, the state has sent you an email on November 30th. And so now you're talking to your client in mid-December to see what he wants to do in regards to the case.
Okay.
All right. At some point, you end up in court, and I'm focusing now on December 27th, December 28th.
Okay.
Because the plea was entered on December 28th, true?
Correct.
All right. The correspondences that were shown to you, well, we've been using the word iterations of this so-called plea agreement. The first one came to you on December the 27th, isn't that right?
Yes.
And so the very first time that you and or Mr. Sledge would have had an occasion to consider the state's proffered plea agreement was one day before he entered his plea. True?
Yes, and to give you detail, that day, I actually, once I received it, went to see him to go over it. And then ultimately, it's when I got back that I sent the response. So that's why you can see I received it around 5 or so in the evening. I didn't respond until about 8 or so at night because I needed to basically go talk to him and get his feedback. And
So-
ultimately, I then sent feedback back to the state.
All right. So we're talking now about maybe 4 or 5 o'clock PM on the evening of the 27th is when you first received from the state this plea agreement that they had drafted up, right?
Correct. That the first one. Yeah.
Right. And again, this plea agreement that they sent to you with the different paragraphs and provisions was something created by them, not by
Objection,
Mr.
Your Honor,
Sledge.
asked
True?
and answered.
Sustained.
And when you went to the jail to meet with Mr. Sledge on the 27th, this would have been the first time that he had any opportunity to look at anything called a plea agreement. True?
Correct.
You would have discussed this plea agreement with him. True?
Well, again, not specific communications
Sure.
with Mr. Sledge, but with all my clients, I'm going to take the plea agreement and go over it with them. So any meeting where a plea is ultimately in the air and being discussed, that yes, I'm going to go get my client's feedback.
So by the time you see him on the evening of December the 27th, 2022, you've got a plea agreement with you, and you're going to have a conversation with him about whether he wants to take this plea, right?
Correct.
Okay. There's still, of course, the option of him going to trial. True?
That remains an option unless and until he takes the plea.
But hanging in the air at that time with the plea agreement on one side and potential trial on the other side was his concern about getting out of jail to see about his sick mother. True?
Objection, asked, answered.
Sustained.
Also hanging in the air was the possibility of him not having the resources to go to trial. Right?
Objection, asked, answered.
And as you would do with any client, you'd have discussed whether or not there were things in that plea agreement that the client simply could not agree to or would not agree to.
Objection,
True?
asked and answered.
Overruled.
I would say again, not specific to Mr. Sledge, but when a client reviews a plea agreement, if there are factual allegations, because there's not always factual allegations in the plea agreement, but if there are, we're going to go over those. And if we go over those and there's some disagreement or there's some need for clarification, that's something that I will go to the state and indicate, hey, there's some issues here. We need clarification or changes or what have you, so that we can make sure these are accurate.
And in this case, you actually did that, didn't you?
I did send an email to the state indicating that there are some clarifications that we would like.
Okay. So there's some negotiations now going on, or some correspondences, communications going on back and forth between you and the state, you on behalf of Mrs. Sledge and the state,
Yes.
from the 27th of December, carrying into the 28th of December, the next day.
Yes.
The next day, he's actually in court.
Yes.
He's brought into court, and you have an opportunity to talk to him in what, a holding cell, a holding area? Outside?
Yes.
Okay.
He's in a holding area. And it's typical a lot of times that client will be one place, the state may be in here or in a conference room, and I'm sort of the messenger of sort, going back and forth to help facilitate a negotiation.
You had the opportunity to discuss with the state that there was a factual allegation in their plea agreement that you did not want, or you wanted changed. Remember that?
Correct.
You talked about number 3.
Correct.
Now, the subject matter of that number 3 revolved around
Your Honor, I object as to the characterization of the number 3, and I'd object based on vagueness. Are we talking number 3 in 1AS or number 3 on one of the other exhibits?
Sustained.
all right.
Check
Let's
out the final version.
yes. Let's let's reference what ends up being the final version of the plea agreement. I believe that's states 1AS. Okay?
Okay.
Do you have those in front of you? I want you to be able to refer to them.
I do not have that in front of me.
Okay.
Okay. My first witness.
You may.
All right. Mr. Wright, I'm going to give you what's been marked as states 1AS.
Mhm.
And I've got some questions I'm going to ask you referring to that document, okay?
Okay.
You had a chance to see what would ultimately become states 1AS and the conditions, the provisions, the factual acknowledgements that were part of that document, true?
Yes.
Okay. Prior to the execution of that document on the 28th of December in court, you had an opportunity to communicate with the state that you had a problem, or y'all had, to use your words, some concerns about that factual acknowledgement, right?
Yes.
Now, that factual acknowledgement revolves around this incident about a video where Mr. 𝐔𝐧𝐢𝐭𝐞𝐝 is alleged to have been in a video holding a gun, making threats to someone else, to another person, correct?
Correct.
When the state presented any of the iterations, including that last one, right, of the plea agreement, they wanted Mr. 𝐔𝐧𝐢𝐭𝐞𝐝.
Objection as to what the state wanted.
Sustained.
The factual acknowledgement revolved around Mr. 𝐔𝐧𝐢𝐭𝐞𝐝 acknowledging that while associated with YSL and to support and express loyalty to YSL, the defendant, that would be Mr. 𝐔𝐧𝐢𝐿, and co-defendant Demikian Garlington and Quindarius Zachary appeared in the video with another person. AS, wherein defendant brandished a weapon used in a drive-by shooting and wherein on behalf of YSL, defendant threatened to harm a person named Kel, a rival gang member who had begun a relationship with defendant's ex-paramour, girlfriend. That was the factual acknowledgement, correct?
That was the factual acknowledgement, yes.
You communicated with the state and you requested that they change that, correct? Or that it be removed.
Your Honor, objection is to compound,
Yeah.
and I don't,
Sustained.
They did not change it.
Your Honor, I object and ask that the, whatever question there was,
Can you pose a question?
Sure. When you saw that factual acknowledgement in the manner that I've just read, in any of the iterations leading up to the 28th, you communicated with the state and asked them that it be changed, true?
Yes.
They did not change it, true?
No, they did not.
Mr. 𝐔𝐧𝐢𝐭𝐞𝐝 still initial that, correct?
Correct. And that's an example of sometimes, as other counsel has asked, you try to get everything you want in a negotiation. Some things you may have to live with. And ultimately, this was an item where someone could try to argue whether two things are true at the same time. That is this just a boy-girl and another boy issue, or is it a YSL issue? But a decision was ultimately made that if it wasn't getting changed, we either had to live with it or stop the process. And ultimately, that stayed.
But the reason that you wanted it changed,
hold on.
when you spoke to the state, you told them that that information was not accurate, true?
True.
You told them that this wasn't the factual acknowledgement that referenced it being done on behalf of YSL, that was not true. This was about a girl.
Your Honor,
And not
objection
about-
as to the compound nature of that question.
Sustained.
You told them that that incident was not about a gang-related incident, true?
True.
You told them that it was about a dispute over a girl, true?
True.
But they did not change it.
Objection, asked and answered.
Sustained.
Were you present, you were present in court when Mr. Sledge testified that he thought that he would have an opportunity to, notwithstanding his initials, explain his answers if put on the stand. Did you hear that testimony?
I did.
Did you again, without going into any privilege and to your observation, well, actually strike that. Did you have a conversation with the state about whether or not Mr. Sledge would be able to explain anything that he had some disputes with in the factual acknowledgements?
The conversation was had back when we were doing the plea, and then even since then, it's always been broadcast or at least made clear by me, hey, if there are some differences in some of the content of some of these, my client will ultimately want to explain. If you put him on the stand and he testifies, he's going to want to explain what he means, as is when he acknowledged this, because something can be true, but also be true with other components to it. It's not always just one way that one person sees it as opposed to how another person sees it. And he wanted to be able to at least explain that. I think he often referred to it as his truth. And that was really him just wanting to explain.
You discussed that with the state?
Yes.
Objection, asked and answered.
Overruled. You can answer.
I would say yes. And again, sometimes the state would agree and they would make changes. Sometimes they would not agree. But it is incumbent on me to make sure, hey, eyes wide open, full disclosure, we've told you. So it was not going to be a surprise that, well, Mr. Sledge may have a difference of opinion.
It was your observation that the state wanted this plea to go through as much as Mr. Sledge did. Is that true?
Objection, Your Honor, relevance as to, and speculation as to what the state wanted.
Wasn't what he asked. Overruled.
True.
I had a belief.
Okay.
Re-
That's also not what was asked.
Okay. Well,
Maybe ask your question again.
You,
And relevance as to what the state wanted.
based upon your conversations with the state, your knowledge of the case, your communications back and forth with the state, your evaluation of the plea agreement, you formed or you observed that the state was just as interested in getting this plea done as Mr. Sledge was. Isn't that true?
So objection,
Go ahead.
objection, it calls for speculation about the state, and whatever his observation is or belief was is not pertinent to any material.
Sustained.
Was it your observation that the state wasn't really concerned with Mr. Sledge, they really
Objection.
wanted Mr. Williams?
Same oh.
Sustained.
And I have a motion as it relates to that.
Make sure y'all hit that subscribe button, man. Hit that like button. Hit that subscribe button for me. Let me know what y'all think about this trial so far, man. How y'all think this trial is?
Okay, I thought you were waiting on the emotion. All right.
Hit that like button. Hit that subscribe button
Before
for me,
Mr.
man.
Sledge
I'm about to
was
drop
brought out
the
into
link.
court on that video that we saw and entered the plea, I know there wasn't a proffer session, but separate and apart from that proffer agreement, the one we talked about earlier that was mailed to you, did you ever get an email from the state saying, hey, we want to talk to him before he enters a plea?
I'm not sure if they asked, but on the same token, my client never expressed an interest in talking to him. So I can't necessarily say it was the state or the defense that kept that conversation from happening. Ultimately, the conversations really were just the negotiations back and forth.
Okay. I got a question I want to jump ahead and ask you about first and then come back to the plea. So the plea is entered on December 28th, 2022, right?
Yes,
You had that meeting that was talked about on June the 9th of 2024, right?
correct.
At any point between December 28th of 22 and June the 9th of 2024, did the state ask you to bring your client in for an interview?
Objection, Your Honor, relevance.
I don't believe so. I know we didn't meet with the state until we ultimately did in June of this year. But we always just sort of figured we were standing by, and it was always our hope we weren't going to have to testify. So we were hoping, hey, we're on the sidelines and we're no longer relevant in this. And then ultimately, it was this year that they said, we need to sit down with you, and yes, you will be testifying.
In 2024,
In 2024.
in the middle of the trial?
Sustained.
Okay. How about this? Did the state ever send you any questions that they might want to ask your client?
Objections, Your Honor.
Can I-
Relevance as to whether or not the state ever sent any questions.
All right, so move on to your next question.
You knew when the plea was entered in December of 2028 that Mr. Sledge was a potential witness to be called at trial. Is that right?
Correct.
Okay. And after he entered the plea, he got out of jail. True?
Correct.
Objection, asked and answered.
Sustained.
He didn't just get out of jail as a result of entering the plea, though. Am I right? There was a bond component of that also, wasn't there?
There was, but
In fact,
Your Honor,
There
I
were
ask
two-
that the witness be allowed to finish his response.
Yes.
I'm sorry, I thought you were done. Go ahead, sir.
well, I was going to say, I think the bond, we worked that out as part of the plea as well, so that was not going to be an impediment to him getting released. So in other words, it really sort of was all connected.
His plea was on count one, the RICO plea, the RICO charge, right?
Uh-huh.
He also pled guilty on count 30, the possession of a firearm by a convicted felon charge, right?
Correct.
He was sentenced on count one.
Correct.
His sentence on count 30 was left open until after this trial concluded, correct?
Correct. In my practice, I find that it's not atypical for states when they do enter into an agreement with a defendant to try to have something held over so that the defendant's participation, they can make sure the defendant just doesn't show up and show out. They come and do what they indicate they're going to do. And therefore, count 30 being held open was not atypical.
Right. His plea agreement and his plea require that if called to testify, he come in and he testify truthfully,
Right.
consistent with the plea agreement, correct?
Correct.
Because count 30 was left open in terms of sentencing, he couldn't get out of the jail unless he got a bond on that charge, true?
Correct.
The state consented to a bond on count 30, didn't they?
Your Honor, I'm going to object as to characterization and the court can check. And I will not speak on evidence, but I believe that this is a matter that
All right. How much longer is your cross going to be? Because we're approaching the lunch hour.
More than half an hour.
Okay, let's break for lunch. And I think we've got a couple of motions to deal with. So let's say, it's 12:30 now. Let's be back at 2. All right, what I may do, because I have a lunch meeting, is let's break now and let's just come back early. So I don't know how long 2 motions and whatever else we have to deal with is going to take. Can we all be back at 1:15? Yes, Your Honor. All right, I'll see y'all then.
thank you, Judge.
Thank you.
And hit that like button, hit that subscribe button for me, man. Hit that like button, hit that subscribe button for me. While they going break, we gonna go over this. We're gonna go over a couple more videos. We're gonna go over this 𝗟𝗪𝗫 stuff. We're gonna go over this 𝗟𝗪𝗫 stuff, and then we're gonna chop it up about a little bit more of what's going on. So make sure y'all hit that like button. Make sure y'all hit that subscribe button, man. Make sure y'all hit that like button. Make sure y'all hit that subscribe button. Remember I said like a couple months back, everybody know Fulio passed away, right? Everybody know Fulio passed away. A couple months back, I was trying to tell people, man, that Fulio got set up by his own camp. They were trying to say 𝐸 did it. They were trying to say 𝐸 had something to do with it. They were trying to say like all this other stuff, but I'm gonna show y'all a video. Let me show y'all a video real fast. Now, Now, I don't think 𝐸𝐭𝐴 has something to do with it. But what I do think is Fulio homeboy set him up. Y'all hit that like right, Nash Money, hit that like button. It's free, man. Everybody should be hitting the like button right now. I understand that the YSL trial is born since YSL Woody left. I understand it's born since YSL Woody left. But my thing is, this is the updates of the trial. Like these parts right here, they be boring, but they be important. These parts be important though. Let me change this thing. Cause I'm about to get back on this Fulio shit again. Make sure y'all hit the like button. Make sure y'all subscribe to the channel. Yeah, because I ain't really, everybody, like, I'm going to do this. Like, subscribe, and share, man. Hit that like button. Hit that subscribe button and share to the live, man. I mean, share the live. Share to the live. Share the live for me, man. Hit that like button. It's like my man Nash Money said. 58 people in the chat, 19 likes. Y'all hit that like button, man. Hit that like button. And shout out to Ratchet TV. I don't like, you feel me? Some shit Ratchet TV be saying he be on point with, but some shit he be saying he don't be on point with. Just like the when he said ATK had something to do with it. I knew they didn't, but what he's saying about 𝗟𝗏𝗡, he's not lying about 𝗟𝗏𝗡, bro. I said that months ago. I'm like, bro, something ain't right about this. You feel me? Something not right about this. Make sure y'all hit that like button, hit that subscribe button, man. So 𝗟𝗏𝗡 said he still have 5 fragments in his arm, and the doctor didn't tell him what he was hit with. And that's against law, especially when you still have fragments, and there's no way he was alert after surgery to talk to a surgeon. Hey, pay attention now. Y'all need to pay attention to this shit, man. As he's saying this, you feel me? I'm not saying this. I'm just reacting to it. This not me coming out and saying, cause I could have came out and said it. I've been said he got 𝗟𝗏𝗡, and I feel like 𝗟𝗏𝗡 and them set that nigga Fulio up. But I want to try to break down details why I think this and why I think that. I'm gonna let somebody else break the details down, and I'm gonna just do a reaction to it. Cause I feel like me breaking the details down is a little bit too policey, you feel me? But me reacting to somebody else breaking the shit down, that's just me reacting to it, you feel me? So that's why I waited till somebody reacted to something like this for me to do a reaction to it, not just me breaking down content to try to basically put niggas in jail. I'm not on the internet to do that, you feel me? I'm on the internet to give my reactions of what I think going on, you feel me? That's why I'm on the internet, to give my reactions. At 3 grades to the head, he still have a head full of hair and an arm, no casket or rod. I was saying the same shit, bro. He said he got hit 3 times. The nigga said he got hit 3 times in the arm, right? I know niggas that got hit 1 time in the arm. Or he could have got hit in the arm, you feel me? It just could have been a flesh wound. It could have went in and out. It didn't have to hit no bone or nothing. See, that too, it could have just went in and out. It didn't hit no bone, but 3 times in the hand, bro, you gonna have a casket, bro. You gonna have, they done broke something, especially with the bullets, the guns they said they was using. And then 1 time in the head, you got no hair loss. I ain't trying to hear that, bro. I ain't gonna lie to you. This shit don't make sense. Said the bullet from an AR-15 does an entirely different kind of violence to the human body. It's relatively small, but it leaves the muscle at 3 times the speed of the handgun bullet. It has so much energy that it can disintegrate 3 inches of leg bone. It would just turn into dust, says Donald Jenkins, a trauma surgeon at University of Texas Health Science Center at San Antonio. If it hits the liver looks like Angelo mold that's been dropped on the floor. And the exit wound can be a nasty, jagged hole the size of an orange. No, for real. Shit, ARPs, bro. Y'all, like, if you said, have you ever went to the range and you shot an ARP? You feel me? And then some 223 bullets be like it'll open the damn thing. It depends what you hitting. It depends like what you shooting at or what you trying to hit. It all depends on what you hitting. But basically what they trying to say is if he got hit with 3 bullets, 3 in the arm and grazed twice in the head or something like that, there should be some damage, bro. There should be a cast, not no damn sling. There should be a cast on his arm. There should be, you feel me? Like, there should be different shit going on, bro. That's why I feel like something is going on, bro. Like, this shit don't seem right. And then they said that once he seen the shooters, why didn't he turn around? Why he kept going? They're going to talk about that in this video, too. You feel me? They're just giving me, I'm just breaking this down. I'm just giving my reaction on this video. You feel me? Because was thinking that, like, man, I feel like on Murder 5 had something to do with that shit. Him and Kenny Caps, man. Them niggas is, I don't know. Them niggas don't seem right to me. A bullet with more energy can do more damage. Its total kinetic energy is equal to 1/2 the mass of the bullet times its velocity squared. The bullet from a handgun is who wrote this? The bullet from a handgun is as observed as it may sound, slow compared to that from an AR-15. It can be stopped by the thick bone of the upper leg. It might pass through the body only to become lodged in the skin, which is surprisingly, it's basically surprisingly. So basically, they're trying to say is he basically saying that handgun bullets is basically like he basically saying like an AR-15 gonna go in, just like I said, it's gonna go in and go out. It's not gonna get stuck in your skin because of the power of the bullet. It's not, you feel me? It's not gonna get stuck. That's why it shit confusing, because if he got hit with an AR-15, that bitch gonna go through you. That bitch coming with so much power. That bitch not gonna get stuck in your skin or nothing like that. That bitch going through you. That bitch not gonna hit no bone, and that bitch going through that bone. That bitch gonna break that bone, bro. Trust me. That's why I said, bro, like the whole story of what he told, it don't seem right to me. It really don't. It really don't seem right to me.
Disney Speedstorm is available now on both mobile and PC with Google.
Somebody said, I believe he or murder set Fulio up to get himself on the map. Listen to what he did. Listen to what he said to say cheese, and listen to what 𝐸 said.
And loyalty go all out the door when money involved. That shit go all out.
You got to think, when I seen this interview, I thought he was talking about the girl, but he's right, bro. Loyalty go out the window with money involved, my nigga. It can be your best friend for years. And if you watch 𝐸5 interview, he's not blaming 𝐸𝐴CE like, oh, fuck 𝐸𝐴CE, like get back on come. He's like, 𝐸𝐴CE supposed to do what he's supposed to do. What? What you mean he's supposed to do what he's supposed to do? This is a nigga take your friend out and you tell that nigga, yeah, you supposed to do what you supposed to do, bro. What? Like, that didn't make no sense. Like, I don't know, bro. 𝐸5 should have been doing interviews before he came out, and he know motherfuckers gonna dissect his lies. You did 3-4 different interviews telling different stories on each interview. People gonna dissect them lies, bro, and wonder why you telling different stories.
I remember we was on the phone a couple days ago, and you said it's fucked up that this shit had to happen for people to know that I could actually rap.
Yeah.
It's fucked up that I had to lose my friend to get notoriety on my music, to get interviews, to get people to reach out to me. And I lost my soul and sense to say the same night I lost my fucking brother.
He said 𝐸 was trolling because he know right before the shooting, him and Fulio got into it.
You when you found out about that?
I was in the bed crying and shit like, damn, niggas out there. Shit crazy.
You shed a tear. I know you guys didn't get along like that, but it's like
we best friends.
No, y'all weren't best friends.
I like twin.
Nah, y'all were best friends. Come on now.
Hey Charles, look, hold on, TK. Hey Charles, I'm gonna show you risk.
Hey, cuz, stop saying that, cuz.
I'm gonna show you, Charles. I'm gonna show you, boy, on God.
Stop, man. I never played with you, cuz.
I'm gonna show you, bro, risk.
Hey,
I'm gonna show you, bro. You know.
Hey, like you man,
boy, you know, boy, I'm my mama, boy, you know.
Hold up, bro. If that's the point, everybody, what? Damn, I just brought you up.
Bro. Hey, Charles, look.
He said, remember how long Fulio stayed sleeping in a coffin, and his mom made a post about surprise. about a surprise. Also, Ace don't believe he gone. He told he played dead before. No, hey, whoever making this video, Fulio did play dead before, and everybody thought he really was dead. But I don't think that though. Young and Ace really know he gone for real. I don't think that Young and Ace don't know he gone. Like Young and Ace know the nigga gone. Young and Ace just trolling. I feel like Young and Ace just trolling at this point. Cause he knows shit. Cause y'all gotta think when that shit happened to Young and Ace, when 3 of his brothers died and he got shot up, you think Fulio was trolling the shit out of it? Fulio was trolling the fuck out of Young and Ace then. I mean, overly trolling. You feel me? Fulio was overly trolling at the time. So when the shoe on, you feel me? When the shoe on the other foot, you can't get mad at Young and Ace for trolling. It's the same shit.
Oh shit, I don't think he did.
What you don't think he did?
Shit, he still coming and posting shit. I don't know if he dead or not. He died in Temple.
Say again?
I didn't know he died in Temple.
You did?
No.
Who you think he died at?
Oh shit, I don't think he did.
What you don't think he did?
Shit, he still coming and posting shit. I don't know if he dead or not.
He commented and posted something to you, but I think it's somebody running his account.
It could be him. Look, they do voodoo and shit. Oh, he probably still here. I'm gonna fucking might pop through the door right now.
What's up? I be spooked.
What's up, Ace? I fuck with you.
Like your craziest voodoo session.
That's all. You can't really speak about.
Oh,
You
okay.
know what I'm saying? You just gotta go to Florida and just, you know what I'm saying? It's certain stuff that how you do. Like you sleep in the graveyard for like 3 days, 4 days to a week. Drink chicken like animal blood. It's different stuff though. Like,
Grandma do voodoo. Hey, fuck it, now I'm playing with that woo. Hey, we just chopped the head off a goose.
That sounds scary. No, not scary. What?
Prior to us getting to the hotel, he had called and made reservations. And then we got to the hotel, he went in, checked in, and they told him that the rooms already been taken. So he came back to the car. He was on his phone trying to find a hotel. I'm just on point watching everything. Looked down at my phone for like a split second. And then something just ain't feel right. So as soon as I look up, I just see, you feel me, shooters. I just kept telling him the dog. He wasn't really saying much. I ain't really hear him say shit, really. Cause the gunfire was so loud. I already knew when I stopped the car, cause he wasn't responding. I heard him take his last breath. When I woke up, I asked my people, and they told me, like they confirmed it. I ain't believe it though. And then when the transporter came and got me and take me to my room, I asked again, like, you feel me, stop playing, like, you feel me, like, where he at? It was like, he gone. You feel me? So we got to the hotel. Went in. The rooms was already reserved, but I guess they had like a glitch in the system or something, so they ain't let us get the room. So then he came back out to the car and we was just chilling, basically, trying to figure out like where we was finna go. I said, you feel me? I just had to handle it accordingly. Shit, my first thought was to pull Fulio out the car, but then I realized my arm was broke and he wasn't responding. So, you feel me? In my mind, I'm just like, damn, you feel me? Just get the fuck out of the car, make sure they ain't trying to come like finish. You feel me? So
right.
I ran in the hotel to get help.
Man.
Yeah.
Honestly.
Hell yeah. Now for that situation, when you was at the hotel and shit, bro, like when that shit first started happening, bro, did you feel like that shit? You felt like you was getting shot at? Cause I'd have been shot before. I ain't know where it coming from. I felt like it was fireworks or some shit. Like what you thought? Like, cause shit moved fast.
I seen them. Like, I seen where they came from. Like,
yeah.
But shit, by the time I looked up, shit had already got started. Shit, like,
yeah, it just.
So my first thought, just shit, get fucked around, really.
Yeah.
I ain't really think nothing else about it, shit. I ain't think I don't know, shit. I didn't think I was gonna get shot and nothing, shit. I thought I was just gonna get us the fuck up out of there.
Yeah.
Really?
In your mind, you wasn't thinking like anything could go down this time, because you know he dropped his low. He know it. Everybody know him and shit. Like you weren't, or you niggas was drunk having fun type shit. Like
of course you gonna always think that, but it's just like shit. It.
Damn. He said, notice how the ops already waiting downstairs and two standing next to him and one recording the whole time. How he didn't see it. He drunk. When you drunk, you're not seeing. When you drunk, the shit that's logical to you, you will overthink. I mean, you will bypass it, you feel me? If you're not an overthinker. See, when I drink, I overthink. So I be watching my surroundings more than you feel me, more than I'm sober. When I'm sober, I really, you feel me, it be normal shit. You feel me? I just be watching my surroundings. But when I'm drunk, I overly watch my surroundings, you feel me? You overly watch shit.
Drink,
You must have a chaser.
Appreciate everybody popping out for my birthday, you know what I'm saying?
Happy birthday!
Everybody got their shot, put their shot with the L, man. Okay, David. Everybody take this shit on 3, man. 1, 2, 3.
And then we got to the hotel. He went in.
You said, wavy, you getting drunk. Why would I be drinking at 1 o'clock in the morning, bro? Is you slow? Everybody was caught for this. Everybody that went to jail was caught for this. What my man's saying is, if you get shot by an ARP bullet, you not gonna just have a sling on. You gonna have a fucking casket. You feel what I'm saying? Like, yeah, they did. But my man's whole thing is, if you did a crime like this, if you got shot inside the arm, you not gonna have a sling on, bro. That's the first red flag. It said that will all depend on a lot of different factors, such as what damage was done, if a bone was shattered or not, if an artery were to have been punctured, or how much muscle was affected, and what was the caliber of the gun. If it was just a 22, probably the person would be released the same day. If it were a 357 Magnum or a 44 Magnum, it's much larger bullet, it likely that extensive damage was done. It could require the person to be hospitalized for several days. Also, how much blood was lost in the event. Too many factors to be able to give you a specific length of time. They say he lost a whole bunch of blood. A cast. They said he lost a whole bunch of blood. All types of shit, you feel me? This shit don't, come on now, man. He's supposed to have way more damage than that. He's supposed to be in the hospital for way longer than that. I said the same thing. X-ray of a broken upper arm after surgery, showing plates and screws. That's when you get hit by a 223, you feel me? That's how your arm should look. When you getting hit by a bullet with that velocity, that's what I'm saying. All them shots and all them bullets were just a graze, bro. That shit don't make no sense, bro. Hell no. All them shots and all them bullets was just a graze. So you telling me you got grazed from all these bullets and all these shots? You got grazed in your arm, and you got hit 3 times in your arm and grazed in your head, and you got no damage. No damage at all. What happened to the nigga in the back seat? If Fulio was jumping in the back seat, why the nigga in the back seat didn't get hit? It's not making no sense to me, bro. None of this shit makes sense. This what this man had on right here. This man had on this. And it's not even when you break something. That's like when you sprain something, or for me. That's why I'm saying, for example, when they hit Ace car up, you think Ace got grazed 3? Ace got hit the fuck up 8 times. That's some shit he bought from Walmart, bro, on my soul. That's some shit that nigga bought from Walmart. A cask is this. I'm gonna show you a cask. This is a cask. That's a cask. That's what he's supposed to have on. That nigga got a sling on, bro. So how we even know if his arm even really fucked up? And then he did an interview a week later and said, yeah, my arm getting better. Moving that bitch and everything like it never got hit. Moving that bitch and everything. I'm like, bro, this nigga is bro, this shit is crazy. He said, you on point with your shit, bro. I fucked with you. No, for real, I've been saying this from day one, bro. I've been saying this shit from day one. Hit that like button, hit that subscribe button, bro. I've been saying this shit since day one, bro. Murder5 had to set this nigga Fulio up, bro. And ain't no way possible you watching. You see the shooters. You drive towards the shooters. Anybody in their right state of mind see shooters, they gonna drive away. Even though if you fuck up, you think you're gonna fuck up, you're gonna try to drive away, do a U-turn or something. You're not gonna drive straight to the shooters. Hell no, you're not gonna drive straight to the people that shooting. Come on now, do that sound logical? He said, low key, I've been watching. I'm just now subscribing and shit. Salute, Cam. Appreciate that, bro. Appreciate that. But I low key think Young and Ace and them gonna get hit with a RICO still. Even though Young and Ace ain't got nothing to do with this, I feel like when the police start canceling shows and shit, bro, there's something they doing some investigating. They doing some, when the police start canceling shows and shit, they doing some investigating, bro. Trust me. Recovery from a gunshot wound to the arm can be complex and may take months or years, even for minor injuries. The severity of the injury and its location are major factors in determination of recovery time. More severe injuries may cause long-term complications such as chronic pain or mental health symptoms. He said, where the bullet had hit after a real examination, I found the bullet had just grazed the forehead of the deer. The skull was still intact. I could just see the bullet has gone across the skull with no penetration of the skull. There was a little bit of fur missing where the bullet grazed the head of the deer. It killed the deer instantly. Even with the modern rifle like a 300 Winchester Magnum, or deer will generally go 5 to 50 yards after being hit. This deer went down instantly without moving after the bullet grazed his skull. So he's showing this examples because it's showing you when somebody get grazed, either their hair gonna be missing or something gonna be missing from them, bro. It ain't just gonna be a nigga have a clean cut after something like this happen. That's not possible, bro. So use your logic thinking, man. Hit that like button, hit that subscribe button. Use your logical thinking on this. Real shit. That's why I got this shit in Atlanta. He said his hair should be missing on the strength that they gonna shave the area around the wound to clean it and shit. Facts. Oh my God, bro. Finally somebody that's from the streets know. If you get grazed in the head, they can't just leave your wound like that. Your wound can get dirty, bro. They gotta cut the hair from around the wound, clean the wound off. If anybody got hit before, or anybody that knows somebody that got hit, y'all know that his story didn't sound right. Something sounded weird with his story. I'm glad that motherfuckers understanding this. Like,
And loyalty go all out the door when money involved. That shit go hard.
I remember we was on the phone a couple days ago and you said it's fucked up that this shit had to happen for people to know that I could actually rap.
Yeah.
It's fucked up that I had to lose my friend to get notoriety on my music, to get interviews, to get people to reach out to me. And I
lost my soul and sister said the same night I lost my fucking brother.
You when you found out about that?
I was in the bed crying and shit like, damn, niggas out here. Like, shit crazy.
You shed a tear. I know you guys didn't get along like that, but it's like
we best friends.
No, y'all are best friends.
Like buds, man. No.
Nah, y'all are best friends. Come on now.
Hey Charles, look, hold on, CK. Hey Charles, I'm gonna show you. I'm gonna show you wrist.
Hey, cuz, stop saying that, cuz.
I'm gonna show you, Charles. I'm gonna show you, boy. On God.
Stop saying I never played with you, cuz.
I'm gonna show you, bro. Really. I'm gonna show you, bro. You know.
Hey, you know, man.
Boy, you know, boy. I'm my mama, boy. You know.
Hold up, bro. If that's the point, everybody. What? I just brought you up,
bro. Hey, Charles, look.
Oh shit, I don't think he did.
What you mean, don't think he did?
Shit, he still coming and posting shit. I don't know if he dead or not. He died in Temple.
Say again?
I didn't know he died in Temple.
You did?
No.
Who you think he died at?
Oh shit, I don't think he did.
What you mean, don't think he did?
Shit, he still commenting and posting shit. I don't know if he dead or not.
He commented and posted something to you, but I think it's somebody running his account.
It could be him. Look, they do voodoo and shit. Oh, he like still here. That motherfucker might pop through the door right now.
That's why I be spooked.
What's up, Ace? I fuck with you.
Like your craziest voodoo session.
That's all. You can't really speak about.
Oh,
You
okay.
know what I'm saying? You just gotta go to Florida and just, you know what I'm saying? It's certain stuff there how you do. Like, you sleep in the graveyard for like 3 days, 4 days to a week. Drink chicken, like animal blood. It's different stuff though. Like,
Grandma do voodoo. Hey, fuck it, now I'm playing with that woo. Hey, we just talked the head off a goose.
That sounds scary. No, not scary. What?
prior to us getting to the hotel, he had called and made reservations. And then we got to the hotel, he went in, checked in, and they told him that the rooms already been taken. So he came back to the car. He was on his phone trying to find a hotel. I'm just on point watching everything. Looked down at my phone for like a split second. And then something just ain't feel right. So as soon as I look up, I just see, you feel me, shooters. I just kept telling him the dog, he wasn't really saying much. I ain't really hear him say shit, really. Cause the gunfire was so loud. I already knew when I stopped the car, cause he wasn't responding. I heard him take his last breath. When I woke up, I asked my people, and they told me, like they confirmed it. I ain't believe it though. And then when the transporter came and got me and was taking me to my room, I asked again, like, you feel me, stop playing, like, you feel me, like, where he at? It was like, he gone. You feel me? So we got to the hotel. Went in. The rooms was already reserved, but I guess they had like a glitch in the system or something, so they ain't let us get the room. So then he came back out to the car and we was just chilling, basically. Trying to figure out like where we was finna go. I said, you feel me? I just had to handle it accordingly. Shit, my first thought was to pull fully out the car. But then I realized my arm was broke. And he wasn't responding, so you feel me? In my mind, I'm just like, damn, you feel me? Just get the fuck out of the car, make sure they ain't trying to come like finish. You feel me? So
right.
I ran in the hotel to get help.
Man.
Yeah.
Honestly.
Hell yeah. Now for that situation, when you was at the hotel and shit, bro, like when that shit first started happening, bro, did you feel like that shit? You felt like you was getting shot at? Cause I'd have been shot before. I ain't know where it coming from. I felt like it was fireworks or some shit. Like, what you thought? Like, cause shit moved fast.
I seen them. Like, I seen where they came from. Like,
yeah.
But shit, by the time I had to look up, shit had already got started. Shit, like.
Yeah, it just.
So my first thought, this shit get fucked around, really.
Yeah.
I ain't really think nothing else about it, shit. I ain't think I don't know, shit. I didn't think I was gonna get shot and nothing, shit. I thought I was just gonna get us the fuck up out of
there.
Yeah. Really?
In your mind, you wasn't thinking like anything could go down this time, cause you know he dropped his low. He know it. Everybody know him and shit. You niggas was drunk having fun type shit. Like,
of course you gonna always think that, but it's just like shit. It.
That nigga story changed like 3-4 times, bro. Yeah, they was already outside waiting on him.
Drink,
You supposed to have a chaser.
Appreciate everybody popping out for my birthday, you know what I'm saying?
Happy birthday.
Everybody got their shot, put their shot in the air, man. Okay, David. Everybody take this shit on 3, man. 1, 2, 3.
Baseball is back. Catch the action live on a.
Make sure y'all hit that like button, hit that subscribe button for me, man. Hit that like button, hit that subscribe button for me. Make sure y'all hit that like button, hit that subscribe button for me, man. Make sure y'all support the stream, man. You feel me? The link, if you want to come up, the link inside the chat. If you want to come up, chop it up with me, the link could be in the chat, man. All you gotta do is.
And then we got to the hotel. He went in, checked in, and they told him that the rooms already been taken. So he came back to the car. He was on his phone trying to find a hotel. I'm just on point watching everything. Looked down at my phone for like a split second, and then something just ain't feel right.
So like, what the fuck is that? Make sure y'all hit the like button, hit the subscribe button for me, man. Hit that like button, hit that subscribe button for me.
The comment was maybe about an hour, 19 minutes and 32 seconds from when we stopped. But specifically, the comment that Mr. Weinstein made, to which the state objected, was, you don't know how the state put those words in your client's mouth. And my objection that the court sustained, obviously, is that it was an improper comment, improper statement put before the jury. And even though the court sustained it, Mr. Weinstein and others' ongoing efforts have been to spin a narrative that the state has forced something on one of the witnesses or more of the witnesses. But those particular words, Your Honor, that you put this, you don't know how the state put those words in your client's mouth. It amounts to Mr. Weinstein making a statement, not asking a question, and him making an assertion that the state, in fact, did something that it did not do, which was put those words in your client's mouth. Everybody's heard the testimony and seen what happened. And in as much as that statement was an improper statement in front of the jury, and it could be construed by the jury as something, notwithstanding any court's instruction, that they could take as fact, we would ask that the court under 17-875 admonish and rebuke Mr. Weinstein's statements and admonish him to make no further efforts to put such improper statements before the jury. My second motion deals with Mr.
Let's take them one at a time, all right? Yes.
There was nothing improper about that question to the witness, Your Honor. I was inquiring about the facts. I'm sorry, I'm losing the word, but the facts that were put forward that the state created. The state doesn't deny that they put those together and gave them to Mr. Wright's client without any input from Mr. Wright. I think it was a proper characterization and it was a question. So the witness could answer that, just as Attorney Love has said. All the evidence is out there. It's all before the jury. The jury can draw what they want from that evidence. So there was nothing improper about that.
All right.
And I actually, well, that's all I'll say.
So I think it was a mischaracterization. It was in the form of a question, but I believe it was a mischaracterization, because if we had been talking about the final version that Mr. Sledge adopted, that might have been a fair statement to say, you know, they were put in his mouth, but these were not things that he ultimately adopted. So the state wasn't putting those words in his mouth. So I think it was a mischaracterization. Don't think it goes so far. I mean, you objected, I sustained it. It doesn't go so far as to warrant an admonishment before the jury. But let's try to be careful in our characterizations, even when we are asking questions. All right.
Yes, Your Honor.
Okay. What's your second motion?
Mr. Adams' question to the same witness that the state objected to but that the jury heard. Isn't it true? And I'm going to paraphrase that you knew that the state didn't want your client, the state wanted Mr. Williams. That's been the lie that they've been, the narrative that has been promoted from the start. We don't agree with it or adopt it. And we certainly don't agree with the idea that we, do these things without a basis for them. So in as much as Mr. Adams made that assertion in front of the jury, we do believe that that merits an admonishment and rebuke under 17-875, and we would ask that the court give him one.
All right, and that statement was essentially, it followed upon another question that was not as objectionable in this way, but that had been sustained. And Mr. Adams, she pretty much doubled down on it and said something to the effect that the state wasn't interested in getting Sledge, they were interested in getting Williams. And that's inappropriate to have asked that witness. And I don't know why you thought that there was any basis for that being an appropriate question, because it would call for speculation anyway. So what's your response to the state's request that you be admonished with regard to that?
Your Honor, it was not a question it was a question that I believed was an appropriate question, given the context of both this witness's testimony and his client's testimony previously. What we'd heard in the narrative that has been put forth, and quite frankly, I believe the evidence has been that the state has been mostly interested in Mr. Williams as a defendant as opposed to the co-defendants, particularly as regards this witness and Mr. Sledge. What has come out and what's been of importance is this meeting that they had on June the 9th, where this statement is made that is beneficial to Mr. Williams. The part about him advising Mr. Copeland or Mr. Sledge to take Mr. Copeland to the police. And that's left out of any questioning of Mr. Sledge. He is asked, or he is, however it comes out. There's no discussion about that. We're not going to ask you about that, whatever portion of it you choose to believe. And so there is this narrative that's out there that they appear to be interested in Mr. Williams, not so much in the co-defendants. And the fact that all of the co-defendants who took pleas were asked, made, or signed plea agreements where the bulk of the plea agreements, and the jury has heard at least 3 of them previously, the bulk of the plea agreements make specific reference to Mr. Williams as the head of YSL. Mr. Williams did this. There is this narrative out there that and everyone has gotten probation. All of the people that the jury has heard from has gotten probation after they were denied bond, and the state took a harsh position that they didn't need to be out on the street. But the minute they entered pleas, they implicated Mr. Williams in some form or fashion in their plea agreements, then they were released. And so that narrative is out there, and I think that was an appropriate question to ask of this witness who has some knowledge of that.
How does this witness have any knowledge of the state's desires about who they most want to get with regard to the 19 or so defendants that are indicted in this case? Because
he is a defense attorney representing one of the co-defendants who entered into assisted in entering into a plea agreement. He is familiar with the discovery. He made a statement in part of his testimony previously that he knew what the case was about. And he started going down the road of talking about Mr. Williams before there was an objection made and the objection was sustained. And so he does have knowledge of that. He knows about the case. He knows that Mr. Williams is alleged in this indictment and by the state's narrative to be the head of this YSL organization. And he knows that the plea agreements have been to the benefit of the co-defendants who have pled and to the detriment of Mr. Williams.
And every other defendant still on trial.
Well, but he also knows, I asked him one question about, was he in court when he heard the statement that was made by the prosecutor before the plea, made by the prosecutor. It was Miss Lizzie Rosenwasser at the time, where the statement was made that we're interested in anyone who wants to make a deal except Mr. Williams. We're willing to make a deal. And so he knows this. We're not doing this in the blind. He's aware of this information.
I'd like to respond.
What's that? Yeah.
I don't know of that statement that Mr. Adams is speaking about, except Mr. Williams. If he could point me to something, because I wasn't there when she said it. I wasn't even on the case, but I doubt that she would have said it. But if she did, I mean, I can't speak to that. I'd like to see it since he's made that assertion. But the second thing is, as it relates to his assertions regarding the plea agreement, Mr. Sledge, I believe, or either Mr. Wright or Mr. Sledge were cross-examined specifically on whether or not the state asked Mr. Sledge any questions about Defendant Williams. And Mr. Sledge said no. And the idea that we're pushing the narrative when the state itself, as the record will reflect, elicited the testimony about Mr. Williams encouraging Mr. Sledge to take Kenneth Copeland to the police station, belies this argument that the evidence that has been brought out by the plea agreements and by the state's actions somehow or another support this, in my mind, baseless assertion by Mr. Adams in the form of, or in the disguise of a question to Mr. Sledge's attorney. There has been, Mr. Sledge's attorney could have been asked whether the state, whether the state asked more questions about one person than another, but actually he was asked and he testified that the question and answer session was more of a kind of get to know you session, and that when Mr. Sledge began talking about Mr. Williams, the state said, the only thing he said about the state is that the state said, that's not the question I asked you. And when he said something about it appeared to be a hot button issue, he later said, there was nothing that you did that made me say that. I just, based on you not asking him about that, I may jump to that conclusion. So putting in front of the witness, this assertion about the state's intention, because as if it's the state that's on trial and that the state is doing something that is just wrong. Is it your impression that the state don't really want your client? He wants Mr. Williams. It wasn't an effort to solicit an answer. It was an effort to put an assertion in front of the jury that was improper, and that can't be taken back. And that has been the entire.
Well, they're going to make that argument.
Yeah.
Regardless, I'm sure they did in opening, and I'm sure they're going to in closing. But I don't believe, Mr. Adams, that there was any kind of a good faith basis to ask that question and to think that was a proper question for this witness to be able to answer. But Ms. Lev, with regard to what you propose is any kind of curative or admonishment, I mean, I don't know what that would be.
I would ask that the court admonish Mr. Adams in front of the jury that the statement he made regarding the intentions of the state as they relate to Mr. Sledge and Mr. Williams were improper statements by counsel, that in those types of statements, the jury is to remember they are not evidence, but that Mr. Adams should not have made that statement in front of the jury.
Okay. And so they weren't statements. It was a question. It was just an improper question. And 17.875 talks about statements of prejudicial matters not in evidence.
And Your Honor, it's not, there's nowhere in evidence. It was a statement that was dressed up like a question, but he made an assertion in the form of a leading question. Was it your understanding that the state really didn't want your client? He wanted mine. And the fact that he dressed it up as a question doesn't take, our position is it doesn't take it out of the realm of improper statements put before the jury that fall under 17.875 that merit admonishment at the very least, even if not rebuke, but that Mr. Adams should be admonished about that statement. It was improper, and it should not, similar statements, even in the form of questions or disguised as questions, should not be made about the state's intention, which one, no one else can testify about, and two, it was just wrong to put before the jury, pretending it was a question to this witness.
Your Honor, if I may respond, please.
Go ahead.
I have this witness on cross-examination,
Yes.
and I'm allowed to ask leading questions. I will defer to the court. If the court felt as though the question was an inappropriate question, there was an objection made, and the court sustained that objection, and I abided by the court sustaining that objection. This does not fall under the ambit of 17.875. This is not tit for tat, where because Ms. Love was admonished previously, now she's trying to find every opportunity to get somebody else admonished. That's not what this is. Now, I'll abide by the court's ruling, by the court sustaining the objection, but I've stated on the record what my belief was and what my good faith basis was for asking that question in regards to the narrative being put forth from the beginning of this case, and I'll stand by that.
I'm trying to look back at what happened right before that. Sustained was, it was your observation that the state wanted this plea to go through as much as Mr. Sledge did. The state objected about on relevance and speculation as to what state wants. Oh, I actually overruled that one. Never mind. Oh, I made it a different kind of ruling, and I said, re-ask your question. Based on your conversation with the state, your knowledge of the case, your communications back and forth with the state, your evaluation of the plea agreement you formed, or you observed that the state was just as interested in getting this plea done as Mr. Sledge, wasn't that true? Objection calls for speculation about the state as to whatever his observation is or belief was. It's not pertinent to any material I sustained. And then you followed that up with, was it your observation that the state wasn't really concerned with Mr. Sledge? I think it was with getting Mr. Sledge, but with getting Mr. Williams, which would also have been asking for, what the state wanted or didn't want, which I had just sustained, but asking in an even more pointed way. So it was inappropriate for you to ask that question. With regard, though, to an admonishment, any instruction I give is just going to highlight it again for the jury. So is that really what you want? Why don't I just admonish Mr. Adams privately not to pull anything like that again, or you will get admonished in front of the jury? Would that suffice for now?
Yes, it does. Thank you.
Okay. Are there other issues we need to raise?
I just like to
I'll
say,
let Mr. Steele.
Okay.
just for the court, or if you'd reconsider, Mr. Copeland made it clear in his testimony that the police wanted Mr. Jeffrey Williams, that all of, he realized.
Yeah, that's a different issue though than the prosecution being just about Mr. Williams, which y'all can certainly argue all you want, but that doesn't make that a proper question to have asked this witness.
And just, okay, maybe you resolved it, but you said something I found interesting earlier. I found a lot of things you say interesting, but thrift, THRIFT versus state, seem to agree with the court's, what I think the court was saying, it's 310 Georgia, 499, it's in Division 7, like 6-7, it's a 2020 case. And it seems to say that a question asked is not contained in 17-8-75, but it says pre-termitting. So I don't think they reached that issue, but they clearly didn't reach it, as a statement. I just wanted to.
Okay, I appreciate that, and I do think that's correct, and so I'm glad to hear that an appellate court also came to the same conclusion. Thank you. Yes, sir, Mr. Sharp.
It's not finished his cross yet.
Right.
I also have a short cross-examination. I wanted, and as you know, Mr. Botts was flying solo this morning, and I want to be clear. I'm seeking guidance from the court. There's an area of inquiry that I wish to get into, but I don't want to be accused of opening any doors.
Okay.
Mr. Attorney Wright, thank you. Attorney Wright has testified that there was one specific, and I'm going to have to go up there to see the number. There's one specific, no, not three. There's one specific provision that he asked to be removed, and the state did in fact remove it.
Okay.
Okay, and I'm not going to dispute anything like that. I do not plan on getting into the contents of number 8, but I do plan on asking Mr. Wright if, to his knowledge from the review of the discovery, his client made any such statement to the police and any such statement to the district attorney. And the reason I'm asking that is, and then I'm going to included. So this is not a situation where Mr. Sledge said one thing at one point and it was now disowning what he previously said, but rather it's just a situation where he's never said that.
Okay,
And that's it. And I'm not going to get into contents of anything, but I just didn't want to be accused of opening the door to the contents.
I think the contents of number 8 are already in front of the jury anyway, because it's one of the factual assertions that Mr. Sledge disputed, and so those were read out, weren't they?
It's very confusing.
They
because
were.
One prior version, number 8,
is not the same as
it's
the
not
ultimate
the
one.
same. So what I believe Mr. Wright what I believe him to have been saying, and perhaps I will confirm by having him point to it when I'm up there, so it won't be read to the jury. I believe he was referring to the part where he said he heard his client heard someone say, "We caught nut."
Oh, yeah.
And then that other number 8 was added in its place. So I'm referring to the original number 8.
Okay, I don't know if that was a number 8 or not.
Well,
You'll
whatever
just have
number it
to-
was.
Yeah, you'll have to, because I don't know if he even gave a number. But yeah, that's fine. But I mean, I think that y'all know from, and that's a legitimate question, but I think y'all already know from maybe our discussions up at the bench that I believe Ms. Love made an argument that his knowledge was based on their post-Nutt's death discussions at the condo. And and I may be misremembering it, but I think that was what Ms. Love at least indicated was her kind of basis for putting that in. So if you ask and no, he never made a statement to police, it's then possible that she gets into that. Although y'all, we are getting, I mean, could we focus on what the issues are in this case, please?
Your Honor, when the court permits, there's one more matter that I think I want to.
Okay, so do you have any issue with if Mr. Short ends up asking, that line of questioning? You're gonna have an issue with that?
My response has to do with what Mr. Wright's answer has already been. I actually didn't quite understand what he's asking. If it'll open the door, I'm not sure what he meant. So if he could clarify so that I can respond to it.
So Mr. Wright is being very clear, and I think the jury gets it, that his client disputed a fact and it was taken out by the state, which I appreciate. But I think that, heck, as an attorney, if I heard that, I would be under the assumption that it ended up in the first place, because he must have said that previously and is now disputing it. I'm not going to get into, the state put this in there without ever hearing it out of your client's mouth. I'm not going to get into the dramatics of that. All I'm just going to try to establish is that, to your knowledge, what you asked to be taken out was something that he never said. Not just that he's denying it now, but he never said it.
Now I understand. So what my response is actually, I'm going to entail a question as well, similar. But so in states 452, while Mr. Wright was on the stand, I asked him about what we're discussing now, and he brought up himself. I don't know how number 8 got in there, something to that effect. And he never said, obviously, I told you to check it out. He said it was an oversight on my part. But I asked him whether it preceded, whether number 460, that email that was sent at 8:43 on December 27th, whether it was sent in response to states 452, which was sent at 506. He said, well, states 506 did not have number 8 in it, right?
Right.
And so that part was fine. But then when he gets to, he said the next thing he sees is states 453, which does have it has a version of, it has a version of 8 in it. But not that exact language.
Right.
As we went back and forth, and he told us what didn't apply and what did apply, what number 8 ended up being was a distillation of that original statement, that it contained only the part that he wasn't disputing. So it wasn't a matter of, and that's a matter for
Your
argument.
version is, that's what he was saying. I think that could be interpreted more than one way. But what Mr. Short wants to ask is, to your knowledge from your review of the discovery and knowledge of the case, did Mr. Sledge ever say, I personally know that somebody from YSL killed Nutt, right?
No.
No?
I'm
Okay. No.
I'm getting everyone. I'm confusing
Confused.
everyone by
maybe
referring to numbers.
Okay.
I understood Mr. Wright to say, I asked, and this is what the state wanted out. I asked the state to remove something. Okay, and forget about the numbers 8 or whatever. What he asked to remove was the statement that someone said,
we got him bad or something.
got Nutt down bad. Okay, regardless of what the number is.
Okay.
And I'm not going to ask him what he wanted to get removed. I'm not going to get into the contents. I'm just going to say what you asked to get removed. To your knowledge, your client never said it, and
okay.
The first place,
Okay.
and when you were representing him, he never told the state that. He never told the state investigators that.
Okay.
Just so it doesn't appear that it's something that he said at one point and is now.
I understand.
So then the question then is not going to be whether or not his client ever said that statement that is now factual acknowledgement number 8.
Right. It's the quote that got taken out from some much earlier version. That is, I don't know where it is because there's so many different versions, but we got that somebody said we got Nutt down bad or something to that effect.
Of course, I'm not going to say what it says.
Right. Okay. But that's what you want to ask about. But you're okay.
And so if the court could inquire if Mr. Sharp, because we have labeled them all so that they're not confusing.
Do you know what exhibit this is going to be on? I mean, I don't know that anybody.
Or just the date and time.
I don't know. Do you have the
I
exhibits
do.
available?
And I gave them
for
to Mr.
review?
Sharp, but
All
if
right,
he'll just
Mr.
tell
Sharp,
me.
can you review and see what exhibit number that is? Because I don't know if it's on more than one. All right, and so if he asks that, he's going to ask, do you know of anywhere from the discovery that might have come from?
Or in his representation, Mr.
Okay.
Sledge ever telling someone from the state that prior.
Which one?
Whatever the quote is.
Yes. Okay. I know it's in Sledge Agreement Updated 2, sent 1:54 p.m. on Wednesday, December 28th.
All right, that's going to be, I think, 455Y.
That is correct. 455Y. And under number 8 in 4.
Sorry, but that is one, that is 453Y. 455Y was the one that was sent on December 28th at 1:54 p.m.
That's exactly what I just said.
I'm sorry, I thought you said 1:45. My apologies. Okay.
So it is 455.
Right, and I'm not saying it's not in other versions, I just know it's
I
in,
don't know whether it is or not.
I
but
just know
okay.
it's in that.
All right, and what number was that, please, sir?
It's number 8.
So it's number 8 in 455Y. Okay,
Correct. But of course, not number 8 in the final version because it's not in it.
right.
Okay.
Okay, so you understand what he wants to ask, is that, and I don't know what you think that might open the door to or not.
I think it might open the door to the fact that Mr. Sledge has testified to the fact that he was at the condo with a number of people, one of which has given a statement that Mr. Kendrick and Mr. Stillwell both indicated that they had killed Donovan Thomas using this language. We caught that in Nut Down Bag. And the fact that Mr. Sledge acknowledged being at that condo during that time, if he starts asking, and he being Mr. Sharp, asks, did your review of the discovery reveal that your client made this statement, then it doesn't have any relevance, given that, one, it doesn't show up in the final version, but two, if his whole purpose is to find out the basis for the state putting it in here first, then I can inquire further about what his client did say and what his review of discovery did reveal, whether or not that statement was alleged to have been made during a time his client was alleged to have been at the condo with the person alleged to have made it. So if that's his only reason, then that's what I would offer up. It's opening a door into. That's just from hearing what I'm hearing so far.
Once again, I'm not getting into the contents, and Your Honor, to answer the question, of course it doesn't open the door, but I was just doing this out of an abundance of caution, and obviously the state is trying to jump through a door
And so
that's
is
not
your
open.
question going to be to Mr. Wright, from however you phrase it, whether Mr. Sledge ever said he personally heard that?
I am going to say, I'm not going to use the words personally heard, I'm not going to use,
All right, what are you going to ask?
I'm going to say, Mr. Wright, on direct examination, you talked about requesting that a
Something
part
different.
of
Yeah.
number 8 on 455Y be removed, and the state removed it.
Right.
And without getting into contents about what it said, is this something based, and I'm going to get into, you're his attorney, you get discovery. Is this something based on your review of the discovery that he ever said to the police? And I'm not going to say what it is. I'm just going to say what you asked to be removed. Is it based on anything he ever said to the police? Is it based on anything that he told to the district attorney or any DA investigators? And I was just going to conclude it and say, Mr. Wright, so the thing that you asked to be removed is not a situation where Mr. Wright, Mr. Sledge allegedly said something and was now going back on it. It's a situation where Mr. Sledge had never said such a thing. And that's it. And I'm not going to say, oh, the state was doing this and that.
Okay.
I'm going to keep it very simple.
Okay.
That's fine, but we've never alleged that the state, that Mr.
Okay,
Sledge.
I think they just want to establish what he just said as his final sentence, that Mr. Sledge didn't one time say it and then disavow it.
Right.
And given that it's not something that has been put before the jury, what it is, I don't know how it's relevant.
Well, I mean, Mr. Sledge's credibility is obviously an issue.
Right. And the state is putting it before the jury that Mr. Sledge has disavowed what's been put in front of him. And I'm just trying to clear it up in front of the jury that
It
he's
is,
not.
yeah, I understand. It's fine for you to ask that question. Do not ask it in a way that suggests that the state has no factual basis for having ever suggested maybe that's something he could
I'm not going to do that.
agree to,
Not gonna
because
do that.
then I will let her get into, here's why we said this, okay?
Completely understand.
All right, everybody understand that? That's gonna apply to anybody that might examine Mr. Wright. Okay,
So,
all right, what else?
so Your Honor, once Mr. Okay, I'm not going to follow up. I'll just redirect if necessary. But number 3, Mr. Wright made a particular statement on cross, I think, as it relates to number 3, or it may have been under rec, but I think it was number 3, and Mr. Adams followed up on it. And the question was, you asked that number 3 be changed, and then number 3, the state refused to change it. Now, given that that assertion has been made and has been affirmed by the witness, we believe that the content of number 3, which I think has already been put before the jury because it was played, I think that the content, just number 3 alone, from Mr. Wright's December 27th, 2022, 8:43 p.m. email to the state, the statement that he makes, the video may have seemed like the issue was gang related, but it was actually about a girl that Sledge was dating, and Kel started kicking it with her. That was the real issue behind that. Not denying the video, but the real issue was the girl. I think that at this point, the language of what Mr. Wright responds with becomes very important because of the characterization made during cross-examination, which was that Mr. Sledge asserted that number 3 was false, and Mr. Sledge has stated that he feels like it was false, and then Mr. Wright asserted that it was false. But the language that Mr. Wright used to correct that assertion does not, it does not assert that Mr. Watts was not a rival gang member. In other words, it does not dispute any material aspect of it. So the only part that we would be asking to Mr. Wright to tell the jury verbatim is what his response was to number 3, so that the jury can fully understand and appreciate what it is that everybody is saying the state refused to change.
I can make this easy. I'll read that number 3 from Mr. Wright's email out loud to Mr. Wright on cross-examination, and the jury will get to hear it. I'm fine with that.
And on behalf of Mr. Williams, I don't have any objection to that. I asked the question, I believe, and it was specifically because Mr. Wright had on cross-examination said that on that one, number 3, he specifically asked that it be either accepted or changed. And so I don't think to that. I think the subject matter of that language is appropriate.
All right.
Okay, good. Then that means I can get, okay.
All right, sounds good. Anything else? Okay, let's get Mr. Wright and the jury. And Mr. Adams, you
Your Honor,
can come on up too.
can we approach really quickly regarding a witness? Hang on.
Yeah. Hold on the jury. Mr. Wright can come on in. very much. Y'all be seated, and Mr. Adams, you can continue your examination.
Thank you. Mr. Wright, welcome back, sir.
Thank you, sir.
All right. I think when we left off, Attorney Wright, I was asking you, we had gotten to the point where I was asking you questions about the actual plea on the 28th of December.
Okay.
So I want to pick up there. All right. At the end of everything, all of the discussions, the plea agreements, conversations with your client, ultimately, Mr. Sledge entered a guilty plea, correct?
Yes.
And he was sentenced, at least in part.
Yes.
And he was released from prison, from jail, true?
Yes.
All right. Part of his sentence, requirement of his sentence was he had a curfew. Is that right?
Maybe so. I'd have to refer to it, but it sounds
okay.
Reasonable.
10 to 6 sound like what you remember, if you remember that?
Again, if the curfew was in place at the time he first got released, yeah.
Okay. It's fair to say that even after he had entered his plea and had gotten out of jail, he had conditions on him pursuant to his plea and sentence, true?
Correct. And it was always an unknown, is he going to have to appear, testify, and, go through this?
But that was, of course, something that was, and I'll use the phrase hanging over his head. That was a condition that was upon him.
Yes.
The possibility of him testifying, true?
Yes.
And of course, the discussions that you would have had with the prosecutor and with your client, again, I'm not asking you specifically what you told him, but subject matter is that if he were to testify, it would be expected that he would testify truthfully and consistent with that plea agreement, correct?
Correct.
All right. Now, it would be fair to say, and you tell me if I'm right or wrong, that you would, of course, make him available to speak to either the state and or the defense in preparation for his testimony.
Correct.
And previously with other clients, and I presume with Mr. Sledge, it would have been incumbent upon you, and you would have discussed with him the necessity of testifying if he were to be called in, testifying truthfully, correct?
Correct.
You've heard the phrase before. He's used the phrase, and it's been here in court, where he said he was of the impression that he would be able to get up and testify to, quote, his truth. You heard that?
Correct.
Okay. You knew and you understood, based on the discrepancies that you had with the plea agreement, that his truth might not necessarily agree with the verbatim reading of the plea agreement.
Objection vague as it relates.
Sustained.
I'll rephrase the question. You knew that he did not agree with everything that was in the plea agreement, correct?
I understood that he did have issues with some of the factual allegations that were contained in it, yes.
Okay. And so moving forward then from that period of time, December of 2022, to when the state made contact with you about speaking to Mr. Sledge in June of 2024, you made him available at that time, true?
Yes.
And if I heard your testimony and the testimony properly, this was a meeting that took place at the Starbucks over in Fayetteville, correct?
Yes.
Would have been yourself, Mr.
We've
Sledge.
gone through who it was. Sustained.
All right. You testified that the meeting that was had with Mr. Sledge at that time was approximately 40 minutes. Is that accurate? Your Honor, I'm entitled to a thorough and sifting cross-examination. I'd like to be able to explore that because it has been made an issue by the state in their questioning.
Okay, I don't know that the length of time of the meeting has been made an issue. Just go on to what it is that you want to get to with this witness and questions.
Yes, Your Honor. Did you describe in your previous testimony this meeting as a getting to know you sort of session?
Yes, it didn't seem like a detailed question answer preparation kind of meeting. Is more of a feeling of feeling each other out, getting to know you kind of meeting, and giving you a general idea of, hey, you're going to be testifying, and therefore, you know, I'll be asking you questions, and so we need to get a sense of each other.
Was there a discussion from the state of, did they advise Mr. Sledge of what they would be asking him?
No, there were general questions again, but it was not, often when you think about prep, witness prep, you think, hey, I'm got 20 questions here, the 20 questions on, it wasn't anything like that. It was really more of a introduction to each other, get to know you kind of meeting.
It did not appear to you to be what you would consider a witness prep session.
Correct.
And that was on June the 9th of this year, correct?
Objection as answered.
Okay, Mr. Adams, go ahead and just focus in on what it is that, I mean, we're all familiar with what he's already testified to.
At any time after June the 9th of this year, and when Mr. Sledge was brought in to testify, did the state ever, in fact, conduct a prep session with him where they asked him or discussed questions they might ask him on the stand?
Objection.
No.
Relevance.
No. That was, like I said, we met the one time, and then we've appeared for trial. And to be clear, we appeared to trial a couple times, but we weren't called, but they did not ask questions or anything. We just sort of waited. So again, trial was really the next instance of any communication between the state and my client.
Did Mr. Sledge at any time ever indicate that he would not comport with his plea agreement and come in and testify? Did he ever exhibit any reluctance to come in and testify?
No.
Did he ever attempt to avoid a subpoena or to avoid reporting when he was asked to report?
No, in fact, for us, in our posture, we wanted to make it clear if they need to meet with us, see us, when we need to come in, we were always going to make sure we are there and make ourselves available so that at all times it's clear we're fully cooperating.
During the course of that meeting, you described, and I'm going to use your words, that when Mr. Sledge started talking about what Jeffrey Williams had said about taking Woody down to see the police, that, quote, the prosecutor didn't seem to like that topic.
What I said then were words to the effect, and I'll say it again now, that she made it clear that wasn't what she asked him, which is true. That wasn't the question that I heard her ask him. But ultimately, just my observations were that it was a topic that she wasn't asking about. And again, it just sort of raised a red flag for me that, is this a hot topic? There's something to that.
When Mr. Sledge testified that the prosecutor said to him, quote, I'm not going to ask you about that, do you have a specific recollection of him, of that being said?
What I can say is, again, I didn't hear Ms. Love say that, but I do know my client indicated that's what he heard. So we were both present, but we heard things differently. So yes, he has always contended that's what he heard. And again, to the extent that what I heard was not the same.
Did he contend that prior to him being put on the stand? Let me rephrase that question so it's clear. Okay. You heard his testimony when he testified to that on the stand, am I right?
Yes.
Had he indicated that to you, that sentiment to you, that that's what he heard prior to him coming in here and testifying?
Yes.
I almost done. Just have one or two last questions for you, Mr. Wright. I want to jump back to early December of 2022, when you were having the back and forth with the state.
Okay.
In regards to the plea agreement. And if I heard you correctly, that was between essentially the 27th and 28th. Is that right?
Yes.
Do you recall stressing to the state or sending them a message, specifically telling them that you were ready, he was good, Mr. Sledge was good to take the plea, he didn't want any media, and that he just wanted to get back to his family? Do you remember expressing that sentiment to the state?
I did.
One moment, please. Attorney Wright, thank you. That's all I have at this time.
Thank you, sir.
Thank you, Mr. Sharp.
Good afternoon, Mr. Wright.
Good afternoon.
Attorney
sir.
Wright.
Good afternoon.
May I approach to just see what the witness has in front of them?
You may.
This is 1AS, which was that final. These are just my own little notes. Shouldn't be. These are all just my own notes. Okay. Sure.
Thank you. Attorney Wright, on direct examination, you made reference to identifying a portion of a certain factual acknowledgement that you and your client disagreed with and bringing it to the attention of the state, correct?
Yes.
Well, you mentioned several, but there was one in particular that the state changed for you, correct?
I need you to give me a little more info on which one.
And I'm not going to get into the contents of it, but it's in what's been marked 455Y.
Okay. I'm not seeing 55. Let me one more time. 6.
State's just any.
Okay.
It is.
Okay. Yes. Yes.
Now, we're throwing a lot of numbers at the jurors.
Okay.
Just so we know what we're talking about, 455Y is not the final plea agreement with the final factual acknowledgement, correct?
No.
Okay. On 455Y, on factual acknowledgement number 8 on that document, not the final document, but number 8 on that document, isn't it true that you identified that factual acknowledgement and said that you had some problems with that factual acknowledgement? And I'm specifically the last part of it.
Yes.
Okay. Now, as the attorney in this case for Mr. Sledge, you received discovery, correct?
Yes.
And you were able to see what your client may have said or did not say to any police officers.
Correct.
Okay, and certainly you were representing your client and are aware of what your client may have said or didn't say to any district attorneys.
Okay.
And you're aware, you would be aware of what your client would have said to any district attorney investigators, correct?
Yes.
Okay. The part of factual acknowledgement number 8 that you asked to be removed, and the state removed it, okay? You with me?
Yes.
The state removed it, we agree?
Yes.
Okay, that part that you asked to be removed, from your review of the discovery and from representing your client never said such a thing.
I can say that my client never adopted that statement. That was one of the reasons he asked it to be removed.
Okay, and I understand he didn't adopt it, but your understanding he never said it. Okay, and that's why I'm just trying to clarify. That portion that you asked to be removed is not something that your client once said and is now disowning or saying he's changed his mind. It's something that was never said.
Objection, asked and answered twice.
That's correct.
Okay, thank you. I just want to talk to you about the timeline of you receiving the plea offer in an actual pleading this case, okay? You received the first version of the factual acknowledgements, you would agree, at approximately 5:00 p.m. on December 27, 2022?
Yes.
Okay, and that was the day before the plea was entered.
Correct.
And as I understand, I'm not going to belabor the point, as I understand, you went to 901 Rice Street, the Fulton County Jail, to discuss the plea offer with your client.
Yes.
Bro, you already got a mod, bro. You don't have to spam my damn chat like that, bro. I'm about to take your mod away. You're going to keep spamming my chat, bro. I don't like when people spam my chat with the same shit, bro. Put it one time. I'm not going to delete it, but damn, bro. You putting this shit like 30 times in my chat. I'm about to take you off my mod shit, bro. I didn't give you a mod to keep doing the same thing. Yeah. Your shit getting took. Make sure y'all hit that subscribe button, hit that notification bell. Nah, bro, you annoying as fuck, bro. Get out my chat. Your ass not allowed in my chat no more. What the fuck on?
Okay, Mr. Sledge. And do you recall how long you met with him?
Your ass will never be a mod again. So you may have to go find somebody else.
That I don't know. It would have been long enough to make sure we're going over things for me to get a good idea of what his response would be to our conversation and the things I was going over with him. And then at some point I would leave. And then, of course, as I said, later prepare a response email to the state.
And this meeting with your client, was this you were in the attorney booth at 901 Rice Street?
Yes.
Okay, and as an attorney, or when you met with Mr. Sledge, you were on one side of the booth, there's a glass.
Objection, relevance is to.
I'm discussing their ability to go over this document. There's a thick glass barrier in between you and Mr. Sledge for this meeting.
Correct.
And he's on the other side of the thick glass, correct?
Correct.
And of course, you have to talk loud, but you can hear each other, correct?
Correct. And let me at least so you know, because this is some time ago, I'm assuming I was, again, because we are almost always in the attorney booth. We get a little key, we can unlock it, we can go in. We can also hand documents back and forth.
Right.
That is my recollection of how I met with him, which meant I would have been able to hand him a copy so he can read it, I can read it, at the same time and go over whatever we need to go over. I'm sort of stating it because it's so long ago. is it possible that I just saw him through one of the more window only kind of things where I could not have handed him stuff? Possible. I don't remember that. I remember being in the attorney booth.
Okay,
But
so
I just wanted to point out that, yes, we can talk as well as hand stuff to each other to review.
Well, let's let the jury know what we're talking about here.
Yes.
So if the attorney booth, if someone's in the attorney booth, if it's being used, if it's occupied, you can use a visitation booth, correct?
Correct.
And that also has thick glass in between you and the person you're speaking to, correct?
Yes.
And the main difference is there's no pass through in those
Correct.
booths.
We can, all audible stuff's the same, but you just can't pass stuff back and forth.
Okay. And of course,
Man, there's 200 people on my live stream. Hit the like button, man. Hit the like button. It's not that hard. Hit the like button. I understand you can go to somebody else's stream and watch it. Well, do that then. Hit the like button. Double tap the screen. If that don't work, there will be 3 dots in the right-hand corner. You hit them 3 dots, there should be a menu that pop up. It should allow you to hit the like button. I need 50 likes. Hit the like button, man. Support the stream.
I have it, sir.
okay, thank you. You would agree?
Not hit the love, bro. Hit the like button. You have to hit the 3 dots in the right-hand corner. Every time I tell y'all to hit the like button, I go on my thing. All you see is my love thing. That's not the like button, y'all. The like button is when the like button. Not this little love, happy, celebration, heart. Not none of this. Not none of that. The like button is on the 3 dots on the right-hand corner of your screen. You have to hit them 3 dots to like the stream, man. There's 200 people on my stream. There should be 200 likes. Make sure y'all hit that like button and y'all supporting the stream for me.
That in the negotiations with the state, your client pled to count 1, which was conspiracy to commit RICO violation, correct?
Yes.
And he was facing 15 years to serve. He was sentenced. The agreement was 15 years to serve on probation, correct?
Correct.
Okay. And then count 30, he did plead guilty, and according to this agreement, sentencing was withheld.
Yes.
And would be dismissed if he fulfilled the agreement.
Yes.
Okay. At this point, sentencing is still withheld, correct?
Correct.
And the maximum he's facing on count 30 is 15 years, correct?
Yes.
Okay. So right when he testified earlier today, he had a 15-year sentence hanging over his head as well as the probation.
Correct.
Okay. And so his maximum exposure is 15 plus 15, correct?
Yes. I mean, technically less, we'll say any time he's already ticked off since the agreement. But generally speaking, it's 15 plus potentially another 15.
So, and at this point, if he's done a year on probation, it would be 29 years instead of 30 years.
Correct.
Okay. Now, you indicated in your review of the final plea agreement, there was one factual acknowledgement that you testified you missed, correct?
Correct.
Number 8 on the final agreement, you missed.
Correct.
And, well, I'm not going to ask you to speak on behalf of your client, but you missed it.
Yes, I can always say that I missed it. And had I seen that, I would have immediately, because it was of a certain subject that from the very
I'm begging for likes, nigga. You begging for somebody to listen to that whack ass music you got, bro. Come on, nah. You in my chat, listen to my music. Don't nobody give a fuck about that music you got, bro. Go find somebody else to go promote your music, nigga. Pay me. Fuck, you not about to keep promoting your music and my shit for free. Pay me. That whack ass music you got, bro. Ain't nobody gonna listen to that shit. Lame ass. I hate niggas like you, bro. Y'all weird. Get your weird ass out my chat. Nobody want to listen to that whack ass music you got, bro. Go find somebody else to listen to that music or pay me to drop your shit in my chat, nigga. What's wrong with you? You said the like button doesn't show if you're strolling through shorts. I had to actually open the live to find a like button. I realized that. I'm not gonna lie, blessed and stressless. I realized that like they don't give you the option to hit the like button. I don't know why. I think YouTube changed. I don't know if YouTube updated. I don't know. That's why I tell people to make sure y'all hit them 3 dots in the corner. Cause if you strolling through shorts and if you find my page, you hit them 3 dots in the corner, and then it should be able to bring a menu up, and it should be able to let you hit the like button and stuff then.
From the very beginning, we had sought to exclude from this, but ultimately, for whatever reason, we missed it.
Okay. Can you, in sentencing acknowledgements number 5 on that final agreement, defendant's sentencing acknowledgements?
Yes.
This final plea agreement between Mr. Sledge and the state, as reviewed by yourself and Mr. Sledge, indicates that your client is facing as much as 35 years.
Bro, y'all in my stream. Y'all can go to anybody else's stream and watch it from their stream. You don't have to watch my shit from my stream. I don't even want you on my channel if you don't want to hit the like button. So lucky if you agreeing with 𝗏𝗏, get the fuck off my channel and go find somebody else to watch. You goofy ass little boy. What did you do? Come on now. You sitting here watching me and you in the comments acting like a little ass girl. Man, get out my face. Well, go stream it then. That's my thing. Why you over here watching my shit if you can go to the news and watch it? Go to the news and watch it. Don't watch my shit. It's that simple. You goofy ass little boy. You getting blocked out my shit. Everybody that come in my chat talking that goofy shit. Bye-bye. Get the fuck out my chat. Goofy ass people. I'm tired of people coming to my chat. Oh, you asked for cash app. Bitch, why you on my chat? This is my job. I gotta make money for my job, right? I'm gonna ask for cash. I'm gonna drop my cash app. You feel me? I'm gonna ask for cash apps. No, it's just a simple fact is motherfuckers be weird. And they all come on these fake ass pages. Oh, he's a bum. He ain't like it. You mad because you can't get 300 people inside your live? You mad because you can't do it? Come on now. Motherfuckers be weird. Bro, so you telling me that Adam 22, his podcast is not a job. You telling me that academics, you telling me that AK-47, when they podcast and that's not a job. Get y'all goofy ass out my chat, bro. And go to the news and watch it if you want to watch it from the news. Fucking goofy.
In confinement. Isn't that correct?
Correct.
That's what the agreement says.
Correct.
Okay. In fact, he's facing 30, maybe 29.
Correct. It would have been a max of 30. So 35 was incorrect.
Okay. So,
Your Honor, I object to the characterization.
Nigga, don't you think I get paid for views too, you goofy ass little boy? Don't you think I get paid for views too? You sound stupid. That little dude, I'm finna pause it again to talk shit. Yeah, I'm gonna talk shit. I'm gonna keep talking shit. I'm gonna keep talking shit. Your goofy ass out my chat. I hate people that come in somebody else's chat want to regulate something. Man, get y'all goofy ass on. Get y'all goofy ass out my chat, bitch.
Language, I'd object to the characterization, and I don't want to speak further, but the question was posed whether it said he faced 35 years, and that is an incorrect characterization. I can.
Okay, do you want to rephrase?
Does the document say that if your client does not fulfill the obligations of this agreement, it may result in defendant being sentenced to serve as much as 35 years in confinement in the Georgia Department of Corrections.
That is what the document indicates.
Okay, is that your client is facing 35 years?
I think it would be a more correct statement to say 30, but point is 30 or 35, a whole lot of time. But yes, I think the correct number is 30.
All right, you're making my point for me.
Gotcha.
You signed an agreement where your client was facing, you and your client signed an agreement saying that your client was facing 35 years.
Correct.
And he was really only facing 30 or less.
Objection, asked and answered.
Yes.
Your client on that final agreement, there's a word that's crossed off and initialed by your client, correct?
Yes.
Okay, begin was changed to being. It's just switching the letters, right?
Yes.
Okay. And that was crossed out and written and initialed by your client, correct?
Correct.
All right, and you've reviewed the video tape. You were in here when the video was played.
Man, Maxie Mac, get your dick riding ass out of my comments, bro. You's a dick rider. You don't know me, nigga. If you do know me, why you coming under a fake page then? Get your dick riding ass out my comments, bro. On my soul, bitch. This is my chat. I can ask for whatever the fuck I want to ask for. The fuck is you talking about? If you go look at AK-47 page right now. He got his Cash App link. Get the fuck out my shit, bro. Get your goofy ass on. Get your goofy ass out my chat. Niggas are goofy. Niggas be goofy as fuck. Oh, he dropped this He asking for cash out. Nigga, I drop my cash out. This my channel. The fuck do y'all not understand? You mad because you not getting no cash apps? You mad because niggas not sending you no money? When you blogging, get your goof ass on somewhere. You niggas be real life goofies. And if you running me if you say that shit to my face, I bet I'll smack the shit out of you. You bitch ass niggas. You niggas be on in my comments like little ass girls. Coming under fake, use your real name, nigga, if I can know who it is. You bitch ass nigga. Niggas be stalkers on different pages stalking. Get your goof ass on. Niggas be weird as fuck. Nigga mad because I'm getting money off my page. This is my page, bitch. I'm not on nobody else's page asking for cash apps. This is my page. I build my page up for me to be able to do whatever the fuck I want on my page. The fuck is you talking about, you goofy ass nigga? Niggas be goofy as hell. And you in my comments. You a fan, bro. You in my comments, nigga. Talking about what I should and what I shouldn't do. What I can and I can't do. Bro, get the fuck on somewhere. Get your weird ass on, nigga.
Of your client taking a plea?
I was there.
Okay. That was something that Miss Love caught and instructed Mr. Sledge to cross out an initial, correct?
That sounds correct, yes.
All right, that wasn't something that was caught by your client.
Correct.
All right. Okay, Mr. Wright, you, in addition to what I first asked you about number 8, the portion of number 8 that you pushed back on the state and they changed, you also pushed back to acknowledgement number 3 on the final plea agreement, correct?
Correct.
And Your Honor, may I go back first?
Yeah.
Goofy ass, bitch ass nigga. Talking about, oh yeah, I know him. I know his uncle named Head. It gotta be somebody that I know in real life.
Push back on regarded the
Goofy ass
video
nigga.
that your client made with Quindarius Zachary, where he was we'll say threatening a gentleman by the name of or Kelvin Watts, correct?
Correct.
Okay. And you're aware that the factual acknowledgement indicates that your client, while associated with YSL and to support and express loyalty to YSL, made this video.
Correct.
And it indicates, the acknowledgement indicates that the video was made on behalf of YSL, correct?
Correct.
Okay.
Your Honor, I'm going to object to characterization.
Sustained. I mean, if you read it carefully and then rephrase.
On behalf of YSL, defendant threatened to harm a person named Kel.
You can ask that.
Okay, but the acknowledgement indicates that on behalf of YSL defendant, that would be your client, Mr. Sledge, threatened to harm a person named Kel, correct? That's what the acknowledgement says.
Yes.
Okay, and you pushed back on that and you sent Ms. Love an email, correct?
Correct. Actually, we began taking issue with that characterization from the very beginning. And this was, I think I testified an example of where we felt one way, the state felt another, and that was one of the examples where it was not changed.
Right. Okay. Do you have the emails? Actually, this might be. Do you have 460 in front of you?
Yeah. 462, 461. One moment.
This is the only 460.
Ms. Love gave me this one. I'm going to approach, if Your Honor will allow. I'm handing you what's been marked as 461.
Yes.
Going to read to you from your email what you said about acknowledgement 3 to Ms. Love. And this email was sent on December 27th at 8:43 p.m., correct?
Yes.
Okay, and this is the night before Mr. Sledge entered his plea, correct?
Yes.
Okay. You wrote regarding number 3, the video may have seemed like the issue was gang related, but it was actually about a girl that Sledge was dating and Kel started kicking it with her. That was the real issue behind that. Not denying the video, but the issue was the girl. Is that what you
Yes.
wrote? And is that verbatim?
Yes, that was verbatim.
Okay, so the point you were trying to get across is you're not denying that your client, Mr. Sledge, made the video.
Correct.
And you're not denying that he had an issue with Kel.
Correct.
But that issue was about a girl.
Yes.
And you ultimately, the state was unwilling to change that factual acknowledgement in the plea agreement, correct?
Correct.
They were unwilling to take out that it was done on behalf of YSL.
Correct.
And they were unwilling,
Your Honor, my objection is vague when the question is they were unwilling to take out that it was done. And earlier, Mr. Sharp referenced video, if you could just clarify.
okay, they were unwilling to change the factual acknowledgements on your client's plea that he was to sign the next day, right?
Well, again, some changes were made, but as to that specific one, that was one example of where they were not willing to change it, even though we had a difference of opinion as to what it was about.
So the it is still unclear. So
And
if you-
factual acknowledgement number 3, I'm sorry. Yeah.
Okay.
Yes, my objection was to, could they specify what it we're talking about?
And it may help.
Factual acknowledgement number 3, which relates to the video that was made
Yes.
with your client and Mr. Zachary in it, correct?
Yes,
Okay. The state was unwilling to change the language that it was done to support and express loyalty to YSL, correct?
correct.
And they were unwilling to change the language that it was done on behalf of YSL.
Correct.
And Your Honor,
Yes.
again, I object.
You can
as to
clear
the
it back
characterization.
up on redirect, or are we already? Yeah, that was,
I haven't
you
done a
still have redirect, so you can clear it up then.
They were unwilling to change the language where it said, wherein on behalf of YSL, defendant threatened to harm a person named Kel because of that individual's association with a rival gang. They were unwilling to change
All
it,
right,
right?
all right. I think that the state's objection is a valid one, and I don't know if you want to, if you need direction, but why don't y'all approach?
Okay, Attorney Wright, do you remember at this moment, in your email, you did not indicate specific changes that you wish to have made, correct?
Actually, in my email, the way I even described I put, here are recommended changes, and then I went number by number, all the way 8 through 13 for
Okay.
the agreement I had at the time.
I get it. It's not like you went through it like you do in Microsoft Word and mark it with red or anything like that, like an editor would, correct?
Correct.
Okay, but the point you were conveying in that email was it was not gang related, correct?
Correct.
And it was over a girl.
Correct. As to that issue number 3.
As to number 3. Okay. And ultimately, the final version of Mr. Sledge's plea agreement includes language. You would agree that it includes language that indicates that the video and the making of the video and the threats were gang related.
Correct. That Number 3 is an example where there was not a meeting of the minds with the state, and that's where they did not remove the information, consistent with what we were suggesting be removed.
And the gang-related versus a girl was where the meeting of the minds was not happening, correct?
Correct. I mean, ultimately, the state included sort of both things in there where we were saying it was really about the girl.
Right. And you told Mr. Sledge that he could explain this later to a jury.
Objection, Judge. One that asked, answered, and province of attorney-client privilege.
Then attorney-client privilege.
Okay. Mr. Wright, from your dealings with Mr. Sledge, you are aware that Mr. Sledge did not completely agree with factual acknowledgement number 3.
Objection, asked and answered.
Sustained.
On the date that he pled, he did initial that factual acknowledgement, correct?
Asked and answered.
Your Honor, this is the first time I'm questioning this.
I know, but lots of other people already have, and we've gotten that information at least a couple of times.
Okay.
I mean, you're welcome to ask whatever it is that you were leading up to.
I believe on cross, you indicated that in negotiations, you can't have everything, and sometimes you have to live with some things, correct?
Correct.
And your client initialing number 3, even though he didn't completely agree with it, is an example of having to live with things, correct?
I think I previously did state that number 3 was an example where there wasn't a complete meeting of the minds, but his choice was to either walk away and proceed with trial or enter into the plea agreement.
To go home, Mr. Sledge would have to live with that as part of the negotiations, correct?
Objection, Your Honor, that part is asked and answered.
Sustained.
All right, here's my question. Is it fair that Mr. Stillwell would have to live
Objection,
with your
Honor, asked
client?
and answered.
No.
I'm sorry. That is not what I meant to add. Objection, relevance, and improper question. Is it fair that Mr. Stillwell will have to do anything is an improper question for this witness. So forgive me for.
Sustained.
Was Mr. Stillwell a party in these negotiations?
Objection, that is, again.
I'll permit that question.
Was Mr. Stillwell a party in these
No.
negotiations?
And-
Was your client signing a factual acknowledgement that wasn't true? Is that something that Mr. Stillwell should have to live with?
Objection, one.
Sustained.
The signing of these incorrect factual acknowledgements, you would agree that it affects more people than just
Objection,
Mr.
Your
Sledge,
Honor.
correct?
Overruled.
I will state this. Any person in a case where there are multiple defendants, once they enter into a plea agreement that includes certain factual stipulations, that can impact all the defendants, not just themselves. So to your point that yes, when Mr. Sledge was completing his plea, his focus was on him. However, there are effects or ramifications that could affect others.
And your focus
Your
was,
Honor,
and
my
your focus
objection-
was
Hang
on
on just a
him.
second. Hang on.
And my objection was to the characterization of the incorrect or improper factual acknowledgement. So the answer, I think, sort of dealt with, but my objection was that that was a mischaracterization or improper characterization.
Was
All right,
factual,
well,
was,
the jury's heard the testimony, so.
was factual acknowledgement number 3 completely correct from your client's perspective?
We indicated that we took issue with some of number 3. Some of it we were acknowledging and some of it we took issue.
And he initialed it and he got to go home.
Correct.
Objection. I
And
asked and
it affects these other gentlemen back here, correct?
asked and answered.
Sustained.
No further questions.
Okay, does any, Joe, questions? Questions, Mr. Williams or Mr. Harvey? Okay, all right. Anybody need a break before we do redirect? Okay, let's take a quick kind of 10-minute break. Try to be back here close to 3. Yes.
Okay.
Hit that like button, hit that subscribe button, man. I got a lot of haters. You feel me? A lot of haters. Nigga talking about, you asking for cash apps. You asking for cash apps. Y'all mad, nigga, and you the main nigga on my channel dropping your songs and shit. Like, bro, get your lame ass off my page. Lame ass, boy. Trying to talk about me and you on my page dropping your, nigga, you on my page dropping your songs, nigga, like you somebody. Your weak ass song. I should have played that shit. Weak ass shit. Shot of Max. What the fuck is that? Nigga talking about some shot of Max. Man, get your lame weak ass on. Nigga talking about some shot of Max. Man. You get his lame ass on somewhere. I can get my mind and then I can go back, bro. I'm trying to change my mind. I can go back, bro. Hold on, y'all. Make sure y'all hit that like button, hit that subscribe button. Bro, obviously the trial is paused, bro. The shit is paused. But it's not only him though, Jay son. It's not only him, bro. A lot of motherfuckers be doing that same shit. They be worried about what I'm doing on my page. Worried about if I'm getting cash apps or not. Like, why are y'all worried about me and what I'm doing on my page? Well, while they on break, we about to go over this Murder 5 incident. We about to go over this Murder 5 incident. And then we gonna go over this Rich Homie Quan after this. Make sure y'all hit that subscribe button for me. Make sure y'all hit that subscribe button for me, man. I just hate when motherfuckers come in my chat and be thinking they can tell me what to do. Like, get the fuck out of my chat then, bro. Motherfuckers come in here, oh, this stream is boring. You comment on my stream to tell me my stream is boring. The only reason you comment because you seen the views. Motherfuckers be weirdos, bro. Don't be liking that shit at all. You come in my chat to tell me something. I hate that negative energy, bro. And then when you go off, people, come on, man. Nobody got time for that. Hit the like button, hit the subscribe button. See people like this, boring. Obviously, I just, like, people be annoying, bro. Not even gonna lie to you. I'm gonna just start blocking motherfuckers. I promise you. If y'all know about the Julio Fulio case, if y'all know about Murderfy, Julio Fulio and them friends, if y'all know about all of that, we about to get into that real fast. We about to play a video of them explaining if this man was hit 3 times in the arm and grazed twice in the head, he would have he would have been in way more pain than that. He would have some type of damage to his body. Some type of damage would be made to this man. You feel me? It just shows you that something not right about this situation, bro. Something not right about this situation. But shout out to Ratchet TV for this video. See, all the shit that Ratchet was doing when he was saying, oh, Ace had something to do with it. Ace set them up. Ace did this. Ace. That's when I was like, nah, he's reaching. He's reaching now. But once he start doing that, once he start putting the blame on Fulio's camp, then that's when I started listening, because I was doing it for me. I realized the same thing. Like, all this shit that went on, it's not adding up, bro. It's not adding up that none of your niggas had a gun, was shooting back. Where was Kenny Caps at? If he was there, he was there on the he was there at the crime scene. Where was he at? Like, you feel me? Like, it don't make no sense, bro. It seemed like Fulio was set up. It seemed like where was all his homeboys at? I mean, y'all should have known. You a city away. You should know that this shit can happen. Y'all supposed to have been ready for whatever that came that night, especially on this man's birthday. Y'all supposed to have been ready for whatever came that night, bro. On soul. It said, Murderfy said he still had fragments in his arm, and the doctor didn't tell him what he was hit with. And that's against law, especially when you still have fragments, and there's no way he was alert after surgery to talk to a surgeon. No, on God. And then, hold on. It say he was hit against the car. He said he still had fragments in his arm, and the doctor didn't tell him what he was hit with. What? So when he went to the doctor, he basically said that when he got hit up, the doctor didn't even tell him what type of bullet, what type of gun he got shot with. He said the doctor didn't even tell him what type of gun he got shot with. And then he said after the surgery, the doctor told him that he still got fragments inside his arm. After surgery, right? How are you alert enough to even know? Come on, man. This shit don't make sense, man. Hit that like button, hit that subscribe button for me, man. Hit that like button, hit that subscribe button for me. And if you from Duval, if you from Jacksonville, Florida, man, hit the link, man. Hit the link. I'm trying to find out what's going on. You feel me? In the inside, I had a whole bunch of motherfuckers from Jacksonville hit my link when I first started talking about it. But when I went to the YSL case, it's like everybody just went MIA. So if you from Jacksonville, man, you know more little inside shit, hit the link, man. I need to talk to y'all about something. Cause this shit don't seem right to me, man. This shit don't seem right to me. And no, I'm not the police. No, I'm not trying to solve a case. It just don't seem right to me. Like from the jump, when the man said he was shot 3 times and grazed 1 time in the head, and no hair was missing on your head when you say you was grazed, yeah, something not right. Something not right. Look, that's a sling, bro. That's something that you get out the motherfucking dollar store, bro. You can go get that out of CVS and Walgreens right now, bro. On my mama, you can, bro. You can go get that out of CVS and Walgreens right now. It seems like all these rappers is getting set up by their own camps or the people they around, bro. Look at Rich Homie Quan. He got set up. And if you don't think that was a setup, man, I feel sorry for you living in this day and age. If you don't think Rich Homie Quan was set up, I feel sorry for you in this day and age. I ain't gonna lie. Wherever you around, boy, they playing the shit out of you. Eddie, you gonna come in my stiff and say the fuck wrong with you? Bro, get the fuck out my comments, bro. For real, get the fuck out my comments, bro. Stupid bitch. Fuck out my comments before I block your ass and you never be able to comment again, ho. I'm about to start cussing y'all bitches out and coming to my comments talking crazy. If you don't want to listen to what I gotta say, don't listen. This freedom of speech. You feel me? I'm the one streaming, okay. So why the fuck you coming on my shit telling me what you gonna say and what you can and can't say and what I'm doing? Come on, bro, get off my shit then. Bye. The fuck? What be wrong with you people, bro? Y'all come on my shit and start talking crazy like this your stream. Nigga, I will block the fuck out of you out my stream. Who the fuck you think you playing with? Goofy ass niggas be all in the comments. You can't even hit the link. You better stay in the comments and type like a little female, bro. Nigga, stay in my comments typing. Who you think you are? Nigga, get out my shit. Look, I'm gonna show you who you is. I'm gonna show you who you is, bitch ass nigga. Get the fuck out my shit. Lame ass goofy. Now you're blocked. You can't comment no more, bitch. The bullet from an AR-15 does an entirely different kind of violence to the human body. It's relatively small, but it leaves the muzzle at 3 times the speed of a handgun bullet. It has so much energy that it can disintegrate 3 inches of a leg bone. It would just turn into dust, says Donald. So if you saying an AR bullet, you feel me? An AR bullet is so strong that bitch can take off 3 inches of your bone if it hit your bone. That's how hard the impact coming. You feel me? That's how hard the impact coming from the bullet. So if impact coming that hard from the bullet, you feel what I'm saying? How the hell he ain't got no cast on? How his arm didn't break? How did it take a week for you to heal up? That don't make sense to me, bro. This shit don't make sense to me at all. This shit do not make sense to me. And if you a real supporter, I'm not talking to you. If you one of these punk ass trolls that like to come in chats and troll all day, yeah, I'm talking to you. I'm tired of the trolls keep coming in my chat acting like they tough, acting like they control my shit. If you a troll, bye-bye. Get the fuck out of my chat. For real, for real. I'm tired of the trolls keep coming to my chat trolling. That shit is annoying. Motherfuckers don't even be talking about nothing. They just come in your chat saying anything. Oh, I like ass. Like, why would you comment that? Go play with your. Go play with something, bro. Go play with yourself or something. Don't come over here and bullshit on my chat like y'all some man. I promise you, bro. I'm gonna get irritated. Motherfucker will come in your chat, troll you, and try to act like, man, we back to the YSL case, man. The YSL case back. We back to this case.
Says that was sent to you before you sent the email in 460 Yankee.
While associated with YSL and to support and express loyalty to YSL, defendant and co-defendant Damian Garlington and Quindarius Zachary appeared in a video with another person, AS, wherein the defendant brandished a weapon used in a drive-by shooting, and wherein, on behalf of YSL, defendant threatened to harm a person named Kel because of the individual's association with the rival gang.
Now, exactly what did you respond with relation to number 3 when you sent that email in 460 Yankee?
Objection. That's
Your
asked and
language.
answered.
What'd you say, Mr. Adams?
Asked and answered.
I gotta allow some leeway.
Go ahead.
In 3, I said the video may have seemed like the issue was gang related, but it was actually about a girl that Sledge was dating, and Kel started kicking it with her. That was the real issue behind that. Not denying the video, but the real issue was the girl.
On any part of 460,
Greg Hayner, bro. Shut your bitch ass up. You think I get if you nigga, I would tell you where I be at, and you still won't do nothing. Shut your bitch ass up and stay on my chat, nigga. Fuck is you talking about? I'm tired of y'all bitch ass nigga. Oh, I know where you be at. Oh, I'm supposed to be scared. I'm supposed to drop. I'm supposed to act like I'm scared. But get your pussy ass off my chat, nigga. If I find out where you be at and really do something, bitch boy.
460 Yankee, or any other communication you made with the state, did you ever assert
I know where
on
you be at.
behalf
Nigga, do
of your
something.
client
Get your bitch ass up.
that Kelvin Watts was not a rival
What
gang?
you talking about, nigga?
No, I did not go into. No.
Okay. And
Bitch ass up.
Your Honor, I don't mind explaining, but I wanted to ask, with the court's permission, certain questions that are frankly binary questions, yes or no. And then if he could be allowed to explain, I would
Okay,
just
well, he said no, and he was
Okay.
about to explain. So you may follow that up your no if you want to with something else.
Go ahead.
I was simply going to say no. But again, the whole point I was trying to make is that it wasn't, from our perspective, really a gang-related issue. It was a girl-related issue. And then ultimately, you did change it. However, the change ultimately sort of included both. That it's a girl issue, but you also kept the fact of some of the YSL and gang contention. And that was just what I would say is sometimes in negotiations, you agree to disagree about, what was at issue.
Okay. I'm going to ask you the next question. Did you ever indicate in any way on behalf of your client that your client was not associated with YSL as stated in the first part of Section 3 of 1AS, the factual acknowledgement?
There has never been a time where I've ever contended or represented to you that my client was not YSL.
Okay. And is there ever any indication from you through your client, from your client through you to the state, that the portion that says where a defendant brandished a weapon used in a drive-by shooting is incorrect, inaccurate, or false?
The answer is no. And further, again, we took no issue with the video. The video is what it is. The issue was just, we were saying sometimes what the motive was. The motive was a girl-related motive, not YSL. Yes, he may be YSL, and yes, the video he does.
Hang on just a second.
Object to the response that he may be YSL, that invades the province of the jury.
Your Honor, we're talking about his
Overruled.
Okay, go ahead.
Maybe, again, it's contended he's YSL. Maybe, and the video is what the video is. We were simply taking issue at the motive or why the video ended up being created had more, it was focused because of this girl situation between two guys. The fact that Kel or my client or whoever they are was a secondary and what we said, not the primary issue.
Okay. Did you ever indicate on behalf of your client in any fashion, whether in 460 or some other way, that the portion wherein on behalf of YSL defendant threatened to harm a person named Kale was false?
No.
All right. All right. So is there any statement contained in State's Exhibit 1AS, Section 3? Is there any portion of 1AS, Section 3 that your client, through you, contended was false? At any time that you conveyed to the state?
The part which says that ultimately his actions in the video.
Wait a minute. Where's the word ultimately in that?
Okay, well, no.
Sustained. He's
Okay.
trying to explain it.
Okay, I'll just start by reading and then I'll pause and explain the part. While associated with YSL, comma, and then here's the part, and to express support and loyalty to YSL. That part is, again, it was not a gang motive. That was the part that my comment would take issue with, that he wasn't shooting this video or making any comments or doing anything. This was about the girl, not about trying to support or express loyalty to YSL. Now, the rest of the, quite honestly, the rest of it is essentially just describing the video. It's correct. And then ultimately at the very end where it was added, had begun a relationship with defendant's ex-paramour. That was correct. So the only issue was an inference that it was in the furtherance or in support and express loyalty to YSL. That was the only part that we took issue with. So that's where, when I say sometimes there's something where we agree, but also part of it disagree. That was the part of disagreement.
And to not split hairs, but did you at any point say in your email or anywhere else that that part is factually incorrect?
No, but also understand my email came the day before. As we started getting into these later versions, I was here in court. I wasn't sending emails. At that point, we were communicating verbally back and forth because we were sort of both here. So
make sure y'all hit that like button for me. Hit that subscribe button for me, man. Make sure y'all hit that like button, hit that subscribe button for me. Comment all positive comments, man. Any negative comments will be ignored and deleted, man. Do not comment on negative shit on my live. I want all positive comments on my live, man. Feel me? Hit that like button, hit that subscribe button. We about to get over into I'm gonna get back to this. We about to get over and I want to do this Rich Homie Quan. I want to talk about this Rich Homie Quan stuff real fast. Not gonna lie, I want to talk about this Rich Homie Quan stuff. I'll get back to this trial. I'll get back to this trial. Make sure y'all hit that like. Make sure y'all hit that like button.
About the death of Atlanta rapper Rich Homie Quan.
His girlfriend found him on the couch inside their home, according to a new incident report. Rich Homie Quan's real name is DeQuantis Devontae Lamar. His girlfriend told police she woke up at 6:45 September 5th to take their kids to school. At that time, she says Lamar was asleep on the couch. When she got back, she says he was still sleeping. She says she checked on him around 11 a.m. and that's when she noticed his body was cold and he was not breathing. Lamar's brother was also in the home. He told police he found Lamar on the floor and moved him to the couch around 3 a.m. This is a developing story. The autopsy results have not been released yet. We have more on the investigation.
So that was Young Thug's brother. Let's go back to that phone call. That was Young Thug's brother, and that bitch had to ask his brother to help his own brother? Oh yeah, something ain't right. Something ain't right. That was Young Thug. I mean, that was Rich Homie Quan brother, bro. And that nigga asking for a nigga named Dre. He asking for somebody named Dre, and his brother on the ground dead. Unlocked. Man, I'm about to watch this. Man, this shit just rubbed me the wrong way, for real, for real.
I need an ambulance.
Tell me exactly what happened.
My boyfriend, he's been asleep on the couch since this morning. Well, he never came to bed last night. Sleep on the couch. I left him on the couch before I took my son to school this morning, put a blanket over him. And now I just checked on him again because he never got up. I don't feel a heartbeat. I don't see him breathing.
And you said, hold on, you said on the couch, and what happened?
I said I put a cover over him because it gets a little cool. He's in the living room. And now I just checked on him because I see he never got up. And I don't see him breathing. I don't feel a heartbeat or anything. And I turned him over. I see he kind of foamed at the mouth.
I'm sorry, are you saying he's not breathing? Is that correct? I'm not hearing you.
Yes, yes.
Okay, ma'am. If there's a defibrillator available, send someone to get it now and tell me when you have it.
Is there a what?
If there's a defibrillator available, send someone to get it now and tell me when you have it.
I'm not sure what that is.
Okay, I'm sending the paramedics to help you now. Stay on the line and I'll tell you exactly what to do next.
Okay.
I need to know about how old he is.
He's 34.
Okay, are you right by him now?
Y'all gotta realize, y'all hear the background change. When the lady asks her, are you with him right now? Y'all hear the background sound like she outside? Why the fuck is she going outside? Y'all gotta know how to do. When the lady asks her, Watch this.
He is.
He's 34.
Okay, are you right by him now?
The person asks, are you right by him now? If y'all realize, y'all heard that change, she's in another room, bro. She was never by him. She's outside some fucking where.
Yes.
Okay, please put your phone on speaker so your hands are free to help.
Can I add his dad to the call? He's trying to call me back.
Another red flag. Why did you call the dad before you called the ambulance? Sound like she was in an elevator. Sound like she was somewhere. This shit don't seem right, bro. And then come to find out his brother there, and you hear his brother on the damn thing. Rich homie Quan sitting there laid out half dead, and all you hear is a nigga, where's Dre at? Bro, ain't nobody reaching, bro. OG6 Falcon, you must not be from the street, gang. You must not be from the street, my nigga. I'm dead ass. Like, reaching for what? What we gotta reach for? This shit sound weird. She not panicking. She not screaming. She not, oh, my. The first thing she came on, she tried to tell a story. Basically, she not even saying my boyfriend unalive. It took 15 minutes until her getting into the conversation to her to tell the person my boyfriend not breathing. That's when the dispatch said, oh, I gotta send somebody out right now then. You should have been said that when you first answered the phone. Come on now, man. This shit don't make no sense.
I called him first before I called you.
Okay, so we need to help. We need to help.
Then, come to find out, Rich Homie Quan was cheating on his girl with all these other females. Come on, bro. You think his female down, you think his wife down look through it? This is his wife. He fucking with Erica Banks. He fucking with all types of female. You think his wife not feeling no way about this shit? Come on, man. Stop playing. Y'all put that marriage, that love shit too. Nigga, it's bro, if you watch Lifetime and all this other shit, you be seeing the fucking wife take out the husband sometimes. Like, come on, man. Y'all act like y'all are lost in this world. It don't make no sense. It's that super reaching, bro. Can't say she ain't in the room or elevator. Makes no sense. No way we would know that. No way we would know that. But a person with a brain will hear the background and hear there's a change in the background. Obviously, there's quiet, and then the dispatch asks her, "Is you in a room with him?" And all you hear is wind in the background. You hear wind in the background. Why it wasn't the same? You feel me? You say, I believe what you're saying, but some of it, I'm not saying, bro, when I'm giving my opinion, I'm not saying this is true. I'm not saying, oh, I know for sure this is true. I'm not saying that, bro. I'm not saying that at all. I'm saying is, if you smart and you know what the fuck, you feel me? Like, some people can't even tell when they being set up. I promise you, some people can't even tell when they being set up. That means your third eye not open. That means you don't see the logic. And the people that's in my comments right now is basically the people that don't see when they getting set up. I can see, like, if I'm hanging with my friends and stuff and they try to set me up, I can see what the energy off, people body language off. You feel me? Like, you would know if your third eye open. He said, running back, Wavy, I didn't check on him in the morning or that night. Nothing is ever what it seems. Nothing is ever what it seems. Why didn't she wake up and ask he was okay, or if there was an issue? They not sleeping together. That's what I'm saying. Like, it don't make any logical woman or any logical man gonna say this shit don't seem right. And then that dad interview, the damn dad just did an interview and he started crying and acting like my song got all these songs and all that. Bro, this shit a money grab, bro. This shit a money grab. That nigga you capping with that Stop it. Bro, I'm not saying that this is true. I'm giving my perspective and my point of view on shit. Facts. Only time you can't see a setup is if it's coming from your own people. On my soul. Say that again, my guy. Say that again. That's the only time you can't see a setup. It's when it's coming from your own people. Let me hit this call back one more time.
Over him and sleep on the couch. Sleep on the couch.
What happened?
I need an ambulance.
Tell me exactly what happened.
My boyfriend, he's been asleep on the couch since this morning. Well, he never came to bed last night. Sleep on the couch. I left him on the couch before I took my son to school this morning, put a blanket over him. And now I just checked on him again because he never got up. I don't feel a heartbeat. I don't see him breathing.
And you said, hold on, you said on the couch, and what happened?
I said I put a cover over him because it gets a little cool. He's in the living room. And now I just checked on him because I see he never got up. And I don't see him breathing. I don't feel a heartbeat or anything. And I turned him over. I see he kind of foamed at the mouth.
I'm sorry, are you saying he's not breathing? Is that correct? I'm not hearing you.
Yes.
Okay, ma'am. If there's a defibrillator available, send someone to get it now and tell me when you have it.
Is there a what?
If there's a defibrillator available, send someone to get it now and tell me when you have it.
I'm not sure what that is.
Okay, I'm sending the paramedics to help you now. Stay on the line and I'll tell you exactly what to do next.
Okay.
I need to know about how old he is.
He's 34.
So
okay, are you right by him now?
You telling me you didn't hear a fucking background change in that? So you telling me you didn't hear you didn't hear a ding ding and so you telling me you didn't hear that? Come on now, bro. I'm not hearing shit. This not Was it not just normal?
I need to know about how old he is.
He's 34.
Okay, are you right by him now?
Yes.
Okay, please put your phone on speaker so your hands are free to help.
Can I add his dad to the call? He's trying to call me back because I called him first before I called you.
Okay, so we need to help your boyfriend now. Okay, listen carefully. Lay him flat on his back on the floor and remove anything under his head.
He is not waking up. Quick.
Ma'am?
Yes.
Okay, you gotta get him to the floor. Lay him flat on his back on the floor and remove anything under his head.
Flat on his back on the floor?
Yes, ma'am.
Help me. What's Drake? He's not here.
Yeah, were you able to get him to the floor?
Yes, his heart not beating or anything.
That is truly heartbreaking to hear that. And is it me or do 911 operators?
Come on now, bro. Come on now. I subscribe, G. I like the content. Somebody showed sounds like doorbell. Yeah, they Google raised no street insight at all. I hear her background changes and script responses. I subscribe, G. I like the content. This isn't even tripping or emotional like you would think she would be. Exactly, somebody entered the room for real. No, for real. But they say that her Rich Homie Quan brother was there. Yeah, from I'm gonna show y'all this new update. there's a new update that say Rich Homie Quan brother was there. So that was his brother.
More about the death of Atlanta rapper 𝐷𝗀𝗏.
His girlfriend found him on the couch inside their home, according to a new incident report. 𝗏𝗏's real name is 𝗏𝗏𝗪𝗏𝗏. His girlfriend told police she woke up at 6:45 September 5th to take her kids to school. At that time, she says Lamar was asleep on the couch. When she got back, she says he was still sleeping. She says she checked on him around 11 a.m. and that's when she noticed his body was cold and he was not breathing. Lamar's brother was also in the home. He told police he found Lamar on the floor and moved him to the couch around 3 a.m. This is a developing story. The autopsy results have not been released yet. We have more on the investigation on the homepage of 11alive.com.
So that made sense to anybody in my chat? That shit made sense to y'all, man. Come on now. He said that don't make sense, dog. I'm sorry. So if my brother was physically there while she asked the 911 operator if she could add the father to the call, the brother ain't have a phone. Yikes. Hey, I didn't think about that. So if the brother was physically there while she asked the 911 operator if she could add the father to the call, the brother ain't got a phone. That's what I'm saying. The brother should have been on the phone with the father. What the fuck was the brother doing? That's my thing. The brother asking for Dre. Who the fuck is Dre? And your brother, Rich Homie Quan, is there on the ground. But you know, when you got a brother that's rich, hey, some niggas go through it. Y'all see Finesse 2 times in his brother. You feel me? Y'all see Finesse 2 times in his brother. Y'all see how they is. Man, make sure y'all hit that like button for me. Make sure y'all hit the like button for me, man. I know it's not on the screen if y'all strolling through shorts, but make sure you hit them 3 dots in the right-hand corner, man. It should take you to the menu so you can hit the like button. Make sure y'all hit the like button for me, man. I need 100 likes on this live. And make sure y'all hit the Cash App. Make sure y'all support a brother, man. It's like my second job, you feel me? It's like my second job. Yeah, I get paid for my views and stuff, but extra money won't help. Extra money won't help either. You feel me? I mean, extra money won't hurt me. You feel me? So hit that Cash App if y'all can. I'm not saying, you feel me? I'm just saying, if you support me, mess with the content, hit the Cash App. Because I'm not like everybody else. I don't make the content. I make the content make sense. You feel me? Wavy gang or no gang. I don't make the content. I make the content make sense. Bro, I got a job, bro. You sound dumb. And I own my own lawn service company business. You sound dumb as hell. I just came back from working when I want to work. If I'm on here doing what I'm supposed to do, if I'm on here doing content, shit. If you want to donate, you want to support, hit the Cash App. You feel me? I'm not saying, oh, y'all got to hit the Cash App. If you want to watch, I'm saying, if you want to support me, if you want to feel like you want to donate to me, if you feel like the content that I'm running is exclusive, you want to send me a Cash App, go ahead. You feel me? I'm not stopping you. But I got a job, bro. Thanks for you trying to say I got a job, bro. And I own my own lawn service company at 25 years old. You fucking goof. I own my own lawn service company at 25 years old. You fucking goof. So go comment on somebody else's shit trying to be funny. He said, nigga die on some shit. Nigga die on some other shit. He said, ain't no setting up there. That's what I think. And they keep bringing the streets in these comments. This got nothing to do with that. He said they had 2 different stories. The girl said he was on the couch, but the news said the brother said he found him on the floor. No, for real. He said, how y'all know this ain't a thug? This ain't a thug play because he was about to be on trial. Y'all got to open your eyes. He said, haters crazy on here not working, talking about get another job. No, for real. How you on my shit talking about get a job? Obviously, you not working if you can comment on my shit. And how you know what I did today? How you know what I got, what I'm doing today? How you know what I did today? How you know what I do? Like, get your hating ass out my comments, bro. And I appreciate that, Lisa. I think she from Detroit, too. Lisa Peach 313. I think she from Detroit. He said, don't even bring thug in it. No, for real, David. These motherfuckers haters, bro. These motherfuckers be hating like a motherfucker. Like, bro, I got a job and I own my own lawn service company business. But nigga, if I'm on here running content and people rock with me, obviously I want them, if they want to support, obviously I get them a place to support me. You feel me? I'm not doing this, I'm doing it to get people educated and stuff. But if somebody want to support me, shit, big bloggers can do it. Why can I do it? No, for real. Motherfuckers like to hate on me for no reason though. I don't understand it. Motherfuckers be hating on me for no reason. It's the only trial he was about to testify in was the Young Thug trial. Pay attention. Open y'all eyes up. Let y'all hear this call one more time. Y'all can decipher what's going on.
Police fire on ambulance.
I need an ambulance.
Tell me exactly what happened.
My boyfriend, he's been asleep on the couch since this morning. Well, he never came to.
Nigga, this is my second job, obviously. This is my second job. 42K bands, whatever your name is. This is my second job. Now hit the cash app, goofy.
Bed last night, sleep on the couch. I left him on the couch before I took my son to school this morning, put a blanket over him. And now I just checked on him again because he never got up. I don't feel a heartbeat. I don't see him breathing.
And you said, hold on, you said on the couch, and what happened?
I said I put a cover over him because it gets a little cool. He's in the living room. And now I just checked on him because I see he never got up. And I don't see him breathing. I don't feel a heartbeat or anything. And I turned him over. I see he kind of foamed at the mouth.
I'm sorry, are you saying he's not breathing? Is that correct? I'm not hearing you.
Yes.
Okay, ma'am. If there's a defibrillator available, send someone to get it now and tell me when you have it.
Is there a what?
If there's a defibrillator available, send someone to get it now and tell me when you have it.
I'm not sure what that is.
Okay, I'm sending the paramedics to help you now. Stay on the line and I'll tell you exactly what to do next.
Okay.
I need to know about how old he is.
He's 34.
Okay, are you right by him now?
Yes.
Okay, please put your phone on speaker so your hands are free to help.
Can I add his dad to the call? He's trying to call me back because I called him first before I called you.
Okay, so we need to help your boyfriend now. Okay, listen carefully. Lay him flat on his back on the floor and remove anything under his head.
He is not waking up. Quick.
Ma'am?
Yes.
Okay, you gotta get him to the floor. Lay him flat on his back on the floor and remove anything under his head.
Flat on his back on the floor?
Yes, ma'am.
Help me.
What's Drake?
He's not here.
Yeah,
were you able to get him to the floor?
Yes, he's not. His heart not beating or anything.
That is truly heartbreaking to hear that. And is it me or do 911 operators sometimes, like, I don't know if she really didn't hear, but they see some silly stuff on the phone sometimes when you hear different videos. But nevertheless, man, that is sad. That's a very, and you wonder how fast how'd that come out so quick? You know, I'm sure it's probably TMZ that got that, but it's just like unbelievable. They're gonna have to wait for an autopsy, obviously, to get his cause of death. Again, there's a lot of people speculating this and that. Who knows? We can guess, we can speculate, but until that coroner does the toxicology test, to find out the cause of death and what was, if anything was in the system, that's only how we're gonna know, what exactly went down in that whole situation. So, yeah, it's rough. anytime you deal with death is rough, but especially when it's unexpected. Like you have your time, it still hurts. But if you know somebody's elder and they're ailing, and you know that the eventuality is coming, so you could kind of prepare yourself a little bit better. But when it just hits you suddenly, and just imagine this young lady, she said she put the cover over him, she left him sleeping. She comes back and he's still just laying in that spot, foaming at the mouth, no heartbeat, no nothing. I mean, it's a tragic experience, and she will forever be haunted by that occurrence, by that day, because she tape.
Need police, fire, or ambulance?
I need an ambulance.
Tell me exactly what happened.
My boyfriend, he's been asleep on the couch since this morning. Well, he never came to bed last night. Sleep on the couch. I left him on the couch before I took my son to school this morning, put a blanket over him. And now I just checked on him again because he never got up. I don't feel a heartbeat. I don't see him breathing.
And you said, hold on, you said on the couch, and what happened?
I said I put a cover over him because it gets a little cool. He's in the living room. And now I just checked on him because I see he never got up. And I don't see him breathing. I don't feel a heartbeat or anything. And I turned him over. I see he kind of foamed at the mouth.
I'm sorry, are you saying he's not breathing? Is that correct? I'm not hearing you.
Yes.
Okay, ma'am. If there's a defibrillator available, send someone to get it now and tell me when you have it.
Is there a what?
If there's a defibrillator available, send someone to get it now and tell me when you have it.
I'm not sure what that is.
Okay, I'm sending the paramedics to help you now. Stay on the line and I'll tell you exactly what to do next.
Okay.
I need to know about how old he is.
He's 34.
Okay, are you right by him now?
Yes.
Okay, please put your phone on speaker so your hands are free to help.
Can I add his dad to the call? He's trying to call me back because I called him first before I called you.
Okay, so we need to help your boyfriend now. Okay, listen carefully. Lay him flat on his back on the floor and remove anything under his head.
He is not waking up. Quick.
Ma'am?
Yes.
Okay, you gotta get him to the floor. Lay him flat on his back on the floor and remove anything under his head.
Flat on his back on the floor?
Yes, ma'am.
Help me.
What's your?
He's not here.
Yeah,
Were you able to get him to the floor?
Yes, his heart not beating or anything.
That is truly, truly heartbreaking to hear that. And is it me, or do 911 operators sometimes, like, I don't know if she really didn't hear, but they see some silly stuff on the phone sometimes when you hear different videos. But nevertheless, man, that is sad. That's a very, and you wonder how fast how'd that come out so quick? I'm sure it's probably TMZ that got that, but it's just like unbelievable. They're gonna have to wait for an autopsy, obviously, to get his cause of death. Again, there's a lot of people speculating this and that. Who knows? We can guess, we can speculate, but until that coroner does the toxicology test, to find out the cause of death and what was, if anything was in the system, that's the only how we're gonna know, what exactly went down in that whole situation. So, yeah, it's rough. Anytime you deal with death is rough, but especially when it's unexpected. Like you have your time, it still hurts. But if you know somebody's elder and they're ailing, and you know that the eventuality is coming, so you could kind of prepare yourself a little bit better. But when it just hits you suddenly, and just imagine this young lady, she said she put the cover over him, she left him sleeping. She comes back and he's still just laying in that spot, foaming at the mouth, no heartbeat, no nothing. I mean, it's a tragic experience, and she will forever be haunted by that occurrence, by that day, because she's the one that had to find this body, man. So, this is a tough business that we're in, man. And I say that because, you know, we cover a lot of stories. We're not like there on the ground and things like that, but we cover and we get to see a lot of things that some people might not even give a damn about. You know, some people might not even know who he is. You know, but when you get into the intimate details, and not many people are gonna listen to the 911 call. Not many people are going to read about somebody's life and dig into every little thing, especially when you interview people. You got to go there. You find out, and then once you sit them down and interview them, a lot of the stuff, and you find out more when you talk to them. So it feels like you know the person. So it's tough, man. Tough situation. But I know you guys want to comment, so I ain't got to tell you to comment on this. But yeah, man, Rich Homie Quan passed away today earlier. Found dead by his girlfriend in Atlanta. Rest in peace, man. Peace.
If you've been waiting to apply for disability benefits, don't. Hi, I'm Sarah, and I'm a lawyer at Atticus. Applying as soon as you're
But the point being is, that was something that my recollection is, hey, we changed it to the extent we're going to change it, and that ultimately you weren't going to change it further or, eliminate that. So my client, as he, I think, testified to, will say, look, some parts I may not have liked, and guess what? When asked, I'll explain it. But ultimately, I don't want to not do a plea. I want to get the plea done so I can move forward. And that's that point of compromise.
Thank you for explaining that. All right. Your Honor, I would also at this time ask the court to conditionally admit 452, 460, and 453, not for publication at this time, but subject to additional restrictions as the court sees fit. And we can discuss outside the presence of the jury.
Admit them. If we want to talk about them more, we can talk about them more.
Yes, Your Honor, thank you. While you were on cross-examination, you testified that some of the factual allegations that were contained in the final plea agreement were not ones that you had agreed to. But on direct, am I correct that you said number 3, you asked to be changed and it was changed, but not exactly like you wanted?
Mm-hmm.
And then number 8 was one that you said today that you missed back at some point when you were reviewing the document.
That is correct. I have said today that number 8 was missed.
Okay.
And a review of it versus our earlier comments to you, they can't be reconciled. I mean, in other words, it's clear that that was not something that we would have anticipated. In other words, it was something we objected to and wanted removed. Ultimately, it reappeared in that final version. We did sign it. Again, I'm not taking issue. We missed it. And unfortunately, had I seen it the day of, I would have paused, stopped everything and said, this is a hard stop. We got to figure this out.
We'll come back to that in just a moment, okay? Other than number 3 and number 8, do I remember correctly that everything else your client through you acknowledged was
Objection, Your Honor. Asked
accurate?
and answered.
Sustained.
When you spoke of some of the factual allegations, were number 3 and number 8 the only two
Asked
you
and
were?
answered.
Sustained.
Outside of what's contained in the final 1AS, is there any other thing that you asked the state to change that we
Your
did
Honor,
not?
asked and answered.
I think that was also asked and answered.
I did. Okay,
Objection.
we'll move forward. Now, as I said, when you mentioned number 8 being something that you had not seen before, are you able to tell the jury the first time that you can now recall paying attention to number 8?
Number 8, when you were questioning my client and number 8 came to light, one of the first things I started to do was go back to read to figure out where that came from. And of course, my reasoning without going into the content was that was one of, from the very early things that we said, hey, this is not accurate. And then I'm thinking, where'd that come from? But I went back, I realized it was there. How we missed it, how I missed it, I don't know. But apparently I did.
If I show you number 8 on 455 Yankee, an email dated December 28th, 2022 at 1:54 p.m., are you able to recall whether this was a document that you reviewed while you were actually in court?
I believe that was one that I did review while in court. I think you said 155?
Yes, sir.
Yes,
455.
455.
I don't know.
455, yeah. Now, without reading out loud number 8,
Okay.
read to yourself number 8. And after you've done so, would you please tell the jury whether number 8 under factual acknowledgements under 455 Yankee is something that you asked the state to change?
If we,
With, just
okay.
because I can't have you read it.
No, I'm not going to read it.
Okay.
But what I was going to say is, having read it,
Mhm.
ultimately, the very final part, the last sentence, really the and then everything after that is the only thing we would have asked to be removed from this paragraph. So essentially, you could say almost the last 2 sentences.
And so $455 number 8.
Yes.
I'm going to object under 403, misleading the jury. Mr. Wright has been referring to number 8 on the final agreement. Now we're talking now. Ms. Love is trying to talk about number 8 on a prior version, which is not the same.
I hear you. I think she was maybe about to ask some questions to clarify that.
I was, Your Honor, and just to be clear, because there was this cross-examination about what was agreed to, what the state refused to move.
Right.
So this, we believe, is a proper line of inquiry, and we'll try and keep it as concise as we can. So, may I continue?
You may.
So, Mr. Wright, when you speak of the change you requested on number 8 of 455 Yankee, does number 8 on 456 Yankee, is that the difference, and is that the line that you're referring to that appeared in the final version?
Well, they are two completely different statements.
Right. And does 456 Yankee contain the line that is now contained in the final version?
No, what I can see is that in 455 Yankee, where item 8 in that document was the one we had been talking about, and we took issue with the last couple sentences of it. When it becomes 456 Yankee, that is moved to being now number 9. The lines in question were in fact removed, but a new number 8 is inserted, and the new number 8 is what I said we missed. We didn't see that because it had not been part of the prior version. So, but you can sort of see by comparing the two that what happened was it got kicked down to 9, a new number 8 was put in, but number 9 does in fact remove the line at issue in the old number 8, if that wasn't confusing.
Not at all.
Okay.
And what I was asking you is that in 456, that line in 456 Yankee, is that number 8, the line that appeared in the final version?
It did.
Okay.
And again, I'm not sure how we missed it. I think because I'm thinking, and again, I can't speak for my client, I can only speak for me, that we were still going off the last thing we had seen. Honestly, I know this final version got emailed to me. I'd be interested to know, just to be sure, what time the plea happened versus this email, because that would make sense as to if I didn't see this last version email,